to limit the extent of the defense's cross-examination of the signed
Your Honor, everything that's in the papers, we don't need to belabor it, because obviously Your Honor knows the state's position with that matter. And further to that point though, Your Honor, and I know counsel's provided a response and that can be heard, but the state also is concerned with not only mentioning the facts, but also the misrepresentation to the jury that somehow the state has control of ultimate sentences. Counsel has gone over multiple exposures. I think one mentioned 38 years of exposure, but then the defendant ultimately received a probationary term. And while the state understands that the counsel is trying to get out in some bias or any favorable treatment, there has to come a point where it's clear that the state is not the ultimate person that makes the decision. We are not the ultimate deciding factor. There are many factors that come into play when we discuss exposure, when we discuss Yarborough factors, when we discuss aggravating and mitigating factors, and of course ultimate determination. In addition to that, when we talk about violations of probation, there are many times that the state argues for state prison, but the court makes a determination based on many factors to continue someone on probation and to make an ultimate decision and disposition. So to represent to this jury that in some way that the state has an ultimate control of what someone ultimately receives as a final disposition, again, is a misrepresentation to this jury, and the state, in addition to believing that the facts of the March 1st, 2019 offense should not come out, the state also believes that there, at this point, the state is seeking some kind of curative or instruction in regards to the fact that the state may make a recommendation, but in the end, the court is the one who makes the ultimate determination as to someone's sentence. Thank you.
Judge, I'm sure you read my submission, you read the unpublished case that I provided. Quite frankly, it sounds like the state's application is basically, Judge, please stop, he's destroying my witness's credibility. That's not what we do here. The case law is abundantly clear. It's not what the state intends, it's not what Mr. Gordon ultimately believes. It has to do with when a witness aligns themselves with a particular party, those are the basics of things. They withheld this evidence and they continue to act with impunity. Like, this is cross-examination 101. And I'm really not going to belabor the point, Judge. We do exposures all the time. That's how it's done. And the court wants you now to basically say, I'm the one who decides what a person gets. I mean, if they want, they can read the transcript from the VOP sentencing where their office continued him on probation. I mean, I have all that stuff. And so should they. So I think the state's implying that, oh, you know, we asked for state prison. Well, they didn't in this particular case. I choose my words very carefully when I say things, and I don't say things unless I know the answers to them, because I don't want to look like an idiot. So I've got everything. They asked that he be continued on probation. So this is typical cross-examination, Judge. Now that you've seen Mr. Gordon testify, I think you get an idea as to what I was saying to you all along about this guy. Thank you.
So when we talked yesterday, not yesterday, Thursday, Mr. Maserati, you indicated that you have hours for.
Well, it depends on how he is.
Okay, so I just want to, in light of what we did see on Thursday, we just kind of set up a little bit more structure in terms of some ground rules, because you know, there are jury members that they're sort of right there, and it's a little bit too close. So what I would prefer that if you need to hand Mr. Gordon any items that he needs to look at, one of the sheriff's officers can just go over to him to kind of keep that buffer, because I want to keep some order and not have anything go left. And truthfully, there were mumbles under his breath, and I want to keep it
And I completely appreciate that, Judge, but that kind of inhibits my ability to have control over the witness, and I'm entitled to do that when I'm cross-examining. I don't have a problem, but what happens when I want to impeach him? It's not him reading the question and answer what's in an impeachment, it's me showing him the page number and the line and reading the question and the answer. Because if we let him go, you saw yourself what happens. And this is who he is. It's just who he is. I can't, like when I'm doing an inconsistent statement or an omission, I can't say, hey, read here for here. I'm the one who's reading that, not him, because I'm reading a specific question and answer. So in order for me to do that, I have to be, I mean, the sheriff's officer can stand there with us. I don't have a problem with that.
I would prefer if you can do it here, or you can do it there, but I just don't want it in that space, because
Well,
I just
can
wanna
we
keep
at
it-
least try the impeachment once or twice and see how it's going before we go there?
it was going there, which is why I stopped abruptly when I did on
I understand
Thursday,
that, Judge.
right?
It kind of,
These
Puts
are my
handcuffs on me.
rules, these are my rules, I'm asking that you simply conduct you. Listen, there was a point where we were in the middle of COVID when people were looking at whatever it is you were showing them on the screen, right? Granted, we're not at that place, but the court has the ability to control the
You do.
mode of cross-examination and so that things are, I see it as my gatekeeping function to not allow things to get to a point where it's going to become disruptive.
you
And
do.
it was getting to that point.
you do, you have absolute discretion in doing that. But I also want you to consider my ability to cross-examine him and control him. Now, I'll do it, I'd love to try to do it that way, and I will. I'll listen to you and I will do it, and I guess we'll give him a transcript, and then I'll point him to a page in line. It may take a little longer, because I know how he is, and then I'll read it from over here or something.
Yes.
And I feel that that's gonna get unwieldy, but I'll try. I have no problem.
And so in terms of the application to limit the extent of the cross-examination, because as I read the submissions, in part, what I understood the state to be saying, well, first of all, the arguments that were raised here in terms of the violations of probation and the extent to which that was a part of cross-examination, I didn't read that in the papers, but what I did understand from the papers was the concern over the details of the March 1st, 2019 incident coming in. So to the extent that at the end of the day, there is discovery that is out there that counsel attached when the application to bar Hassani Gordon from testifying. All of that discovery that was in the hands of the defense was in fact turned over to the state. I had an opportunity to read it, and there's a lot there, right? The extent to which Hassani Gordon may or may not have had some of that information is not entirely clear. I think it's certainly inappropriate to ask that, or to indicate that he had in fact been charged with the conspiracy, he had been charged with distribution, and those charges ultimately were dismissed, and they were dismissed after he gave this last statement to the prosecutor's office. To the extent that there was a whole lot of investigation related to that particular incident, and in large part, likely because someone did die. And it seems to me that whether or not Hassani Gordon had that information is a question that can be asked of him, because the question becomes, you know, I think appropriately asked of him, just that he was not charged with a drug-induced death, because he wasn't. And to the extent that he knows that, or he doesn't know that, you're kind of stuck with his answer.
Sure.
Right? So, and then we move on. But the specific details of that, it was, you sold 20 bags of heroin, like all of that is not something that needs to go before the jury. What needs to go before the jury is that there was an investigation, and this was an investigation that was happening before you gave your statement to the Middlesex County Prosecutor's Office, and then you were never charged as a result of whatever that investigation revealed with a drug-induced death. And I think those are appropriate questions. I don't think I need to go through every specific question that need to be asked, but the details of the investigation, that they were CDWs, all of those things do not need to go before this jury.
I never intended on doing that, and my cross-examination of him on this issue is, obviously, I'm going to ask him, you're aware that as a result of this distribution, somebody died. The police investigated the case. You were charged some time later, but you were not charged with this crime. Well, I'll name the crime. It's really, I'm not going to say on this day there's some, and the other thing too, Judge, is he kind of put his foot in his own mouth, right? He says, I didn't do it. He creates the impeachment when he lies or he denies the conspiracy to distribute and the distribution, right? So at that point, and I addressed that in my moving papers, that he created his own impeachment by saying, I didn't do it. And not only that, double jeopardy has not attached to that. He and his sister can be charged with that right now. So it's kind of, that's the other argument that I made in our paper, that's kind of hanging over him and his family's head, because his sister was never charged with any of this. So again, it goes to his alliance with a particular party. I'm not going to sit there and say, well, you cut up the bags and you bagged them up and you set them up there. Just generalities and about what he avoided, what his family avoided, and moving on. So that's kind of where I'm going with this.
You wanted to respond?
Just very quickly, there's absolutely no proof that the drugs that may have been sold to this individual caused his death. That's the reason why he wasn't charged. There's utterly no proof that these drugs contributed to his death. It would have been dismissed on a motion to dismiss. So that's why we're objecting to any question related to that specific aspect of this. I think we've conceded the other points. It's just that specific aspect.
I don't understand how the state can even say that. I just don't understand, but that's irrelevant, really, at the end of the day. The guy drops 30 minutes after he does one or two of the bags of the 20 that were dropped off to him. It may not be a rock-solid case, but you definitely charge that case.
So that's my ruling. It seems to me that was ultimately the subject of an investigation that didn't go anywhere. He was not charged. And if the state wants to make the argument that there are a whole host of reasons that people don't get charged and none of them apply to Hassani Gordon in terms of his receiving some type of favorable treatment, then that's certainly, you're free to do so. But on paper, when there's certain facts upon which there is a good faith basis to ask a question to determine whether or not there was in fact any reason. Because listen, at the end of the day, he may very well say, I didn't know the guy died, and I don't know what his response is going to be, but a lot of this is about his subjective belief about the extent to which he was avoiding a certain level of exposure, right? And so he may very well say, like, well, I didn't know that, so I had no reason to to cooperate with the state based on that. That wasn't something that I was concerning myself about, because whatever his response is, I don't know what his response is going to be. So, so that's so the other thing is this, right? So there were a lot of questions about, as the state pointed out, the witnesses' exposure, and there were points at which he said, listen, I don't know, I'm not a lawyer. And I think if we're going to continue this line of questioning, the extent to which we need to repeatedly go over, you know, a third degree is 3 to 5 is really unnecessary, because once he says, I don't know what that's his answer, right? So I think we can sort of move it along in that respect. He may or may not have known exactly what his exposure is, but if you ask the question and he says, I don't know, we gotta move on.
That's fine, Judge, but just so you're aware, in prior transcript and even on direct examination, he acknowledged what certain exposures were. He's saying, I don't know to me. He's not saying...
And so if you have that to show that
Sure,
in fact
and
does know.
listen, I'm not... That part, I'm gonna go to the last one, because the last one came in bungled, and I'm moving on. I'm gonna go into the area of the charges that he avoided, which is what we just talked about, and I'm moving on. I did not expect not to be able to approach him with a transcript, so there's some transcripts there I don't have a copy of here. I gotta run to my office and print a couple of them. So just so you know, I never had that happen. So that's why I lined them up there, so I can refer to them.
Judge, we have copies if there needs to be a copy.
Well, there's one you don't have a copy of because it's a transcript from Thursday. So I gotta get another copy so I can give it to the state if I use it, right? So that's one thing at least I have to print. So I'm just, you know.
Okay. I mean, it's not as if I'm saying to you, you gotta cross-examine from the other room, right? I'm just saying, give space between you and the witness.
May I approach right there?
Yes.
So if I'm here, okay, and I want him to read, I want to read a question and answer to him for him to follow along.
Right.
He's not going to be able to see it, right? I have to be here, and he has to be able to read it himself. So he's got to have one, and I got to have one. If you want to do it.
So right there, page so-and-so, line so-and-so, question so-and-so.
I'll try, but he's got to see it. No?
Sure. Well, you can direct him to page and line.
But I'm saying I need two. I need the one he would have, and I need one in my hand.
Right, and you don't have the extra.
Not for
is
all
what
of
you're
them.
saying. Okay.
So I need to, yeah, not for all.
Let's go with the ones you have for now, and then you can
Judge,
get the other ones. Or is somebody in your office that can?
yeah, I just got. I mean, it'll take me 2 minutes.
Okay.
There's an order to my cross. I really need them all here. I don't want to disrupt you.
Understood.
So I can run over and do that?
You
Or?
got it. Nobody can bring it over?
I gotta tell them, but again, I need it to start, Judge. So you give me 5 minutes, I'll.
5 minutes.
Thank you.
That's a jury on?
Yes. Be right back.
You want to address the?
Yeah. Judge, the other issue I addressed was the pipe impeachment issue. That was the one issue that, you know, I mean, there are others, obviously, that I intend to impeach on what he claims he saw. You know, in one statement he says he saw, another statement he says he didn't because someone told him. I'm not asking him, and I addressed that issue, I think, as to how the impeachment would go. I don't think that opens the door to anything. I'm asking him what he saw, what he didn't see. And that's part of the kind of some of the issues that I was discussing with you earlier related to being able to cross-examine him. This is one that I don't think crosses into that land, but I just want to. I addressed it in my moving papers. And I can tell you how the questions would go, you know, if you want. No problem. It's not secret.
Yeah, let's talk about that, because what's your position on that issue?
Your Honor, Council had mentioned that it was Wayne Stecker who ultimately told Mr. Gordon about this pipe, and that was not what happened. Meaning Mr. Gordon stated when he said he didn't see the pipe, but he heard that he had a pipe, that he didn't see it, that he heard from Wayne Stecker. And Council stated that Wayne Stecker never said that he saw a pipe. And so all of this leads to the fact that Gordon is making this up. Again, Your Honor, the state made it clear, I believe that we're opening the door now to Mr. Stecker and what Stecker said or didn't say, which obviously we know it was at issue at the first trial. At this point, let's see how it comes out. Let's see what happens. And if I've already made clear that if it's just to try to impeach Mr. Gordon, I understand that. However, if we talk about whether or not Wayne Stecker had anything to do with what was said or what was relayed to Mr. Gordon, I mean, I think then we have a problem. The state, I want to be clear here, we have another witness testifying today, Ms. Edwards. We absolutely plan on bringing in the fact that Wayne Stecker is no longer with us. That's relevant because these are three people that were in the house. When the state has an obligation to bring the people to court to testify as to what happened, if one of them isn't here and can't testify, and it's because they're no longer with us, that just needs to be clear to the jury for completeness. But other than that mention of Mr. Stecker, the state doesn't plan on in any way having any testimony as to what he said about a pipe or what he saw that night or anything of that nature. So if counsel gets in to make it seem like it's just impeaching of Gordon in regards to prior statements that he gave, the state has no problem. But we'll see how it goes in and then we can go there then.
Can I see how you're, because the concern I have is that what was testified to on direct was very limited. And so I don't see how, let me hear.
So the questions to him are gonna be very pointed. You didn't see Tim Puskas leave the house that night with a pipe as long as your leg. He's going to say no. And then I'm going to impeach him with what he told the police on March 20th, 2014, that he said on that day he saw with his own two eyes Tim Puskas leave the house with a pipe. That's it.
That's accurate.
I mean, that's it. I mean, it's an impeachment. It's a prior inconsistent statement, and it's clean. There is no Stecker. There is no, I'm not talking about Stecker. I'm not talking about any of that. And I think he should be instructed not to ever say, I heard it, or I this, and I that. I mean, we should probably tell him a few things this morning as well. As it relates to Mr. Stecker, Mr. Stecker's no longer with us. That's an issue that we'll deal with when we get to it, Judge. That's something that came out of left field, but we'll deal with that, I guess,
Let's get Mr.
when we finish with Mr. Gordon.
Can you bring Gordon in?
So I would appreciate the court saying to him again, not what you heard, listen to the questions, what you saw, you know, don't say I heard this or I heard that. I would really appreciate that, Judge.
Morning.
Mr. Gordon, good morning. All right, so the jury's gonna come in a little bit, and I just wanted to, because we're gonna pick up where we left off on Thursday. So just make sure you're listening carefully to the questions. If there's a question you don't understand, ask. And make sure you're testifying only about things that you know of personally, not based upon what you may have heard from anybody else, right? So if a question calls for you to respond with something that you heard from somebody else, then presumably there'll be an objection and we'll deal with it. But don't blurt out that you heard anything from anybody else. Okay, all right. We'll bring in the jury. He can remain here because he's sworn in on Friday, on Thursday. I want to thank you for your patience. You may all be seated. Mr. Maserati.
Does Mr. Gordon need to be sworn in again, Judge?
I'm sorry.
Can I begin or does he need to?
Yes, you can be. Mr. Gordon, I'm going to remind you, you were sworn in on Thursday. You're still under oath today.
Mr. Gordon, last week, I couldn't get my hands on we were talking about PTI, remember that?
Yes, sir.
And I couldn't get my hands on the plea form for your November 1st plea. Okay? So I'm going to now show you D-241. May I approach?
Yes.
Judge? Take a look at D-241. On page 5. You want to flip to page 5, Mr. Gordon?
You could leave it in for him to do it. Flip to page 5.
It's the last page. You see the last page, page 5?
Yes, sir.
You see the paragraph where it says PTI, you're going to make a PTI application, right?
Yes, sir.
Okay. So that's what we talked about last week, correct?
Yes, sir.
That's good. That's good. Thank you. All right. And I think we left off, we were talking about your arrest from May 24th, 2021. Now, on May 24th, 2021, you were taken into custody on charges that had issued almost a year before then, on July 7th, 2020, correct?
Correct.
And those charges were a distribution of heroin charge, correct?
Yes, sir.
And a conspiracy to distribute heroin, correct?
Yes, sir.
And we talked about your exposure on those charges last week. You gave a statement on October 21, 2021, correct?
Correct.
I didn't hear you, sir.
Correct.
And that was the newest statement you had given in this case, correct?
Yes, sir.
And on December 1st, 2021, your case was dismissed, correct?
Yes.
So I've added up your potential exposure. That's up to 79.5 years, and you got probation, correct?
Yes.
All right. So last week, Mr. Gordon, when we were talking about these charges, you were adamant that you did not sell heroin to Mr. Batia, correct?
Yeah.
So the answer to my question is you were adamant that you did not, correct? So I'm correct.
Yeah.
And you said you were in Georgia at the time, correct?
Yes.
But you do acknowledge, Mr. Gordon, you were charged with a conspiracy to distribute that heroin, correct? We just went over that.
Yes.
And when you were arrested on this charge, you had to go to court, correct?
Yeah.
You went to court with an attorney, correct?
Yeah.
Mr. Fazioli, correct?
Yeah.
All right. And you and Mr. Fazioli, as you went through the case for the several months that, it took from the time you were arrested to the time it was dismissed, you discussed the case, correct?
Yeah.
And you discussed that case just like you've discussed other cases in the past with your attorneys, correct?
Yes, sir.
That's what happens when you're dealing with an attorney. You're the client, right? And the attorney goes over the discovery with you, correct?
Yes,
The charges, correct?
yes.
And a whole host of other documents that are part of the case, correct?
Yes, but in this case, no. I didn't go over anything.
Okay, well, you already told me that you discussed the case with him,
I
right?
discussed it with him.
Okay,
This is,
so I'm going to show you D. I'm going to mark this D. D250. You have Facebook, correct? This is yours. Showing you D250. That's the Facebook. That's the Facebook conversation you had with Mr. Bertia back in March 2019, correct? You've had an opportunity to read the messages between you and Mr. Bertia?
yes, sir.
That's the Facebook conversation or a Facebook message or conversation you had with Mr. Bertia in early March 2019, correct?
Yes.
And I'm going to just summarize the conversation.
Hold on, let me see this. consistent with our discussion to move on.
Mr. Gordon, as it relates to those charges that were dismissed, the distribution and the conspiracy to distribute charges, you became aware that Mr. Batia overdosed, correct?
Yes,
And you're aware that, and he overdosed, and not just overdose, he died. You're aware of that, correct?
Again, Your Honor, the state's objection for the same thing, it was placed on Michael Breyer.
He answered the question, ruled.
And you're aware, Mr. Gordon, that it's a crime when someone distributes a substance, an illegal substance to somebody else, and they die as a result of that distribution. You're aware of that, correct?
yes,
And you're aware that is a first-degree crime, correct?
yes,
And you're aware that that crime, if you're found guilty of that crime, you can face up to 20 years in prison, correct?
yes,
And potentially, because you had prior felonies.
this case was dismissed.
I understand that. I understand that.
Why are we even discussing it?
And
It's dismissed.
So hold on. I think you can ask counsel whether or not those discussions were had with him, and if they were not, you need to move on.
I'm just asking right now about what he knows.
Well, you have to tie it in, and so to the extent that you're asking whether or not, ask first whether or not those discussions were even had with him.
You were never charged with that,
No, No.
crime, correct? And the person that you conspired with, they were never charged either, correct?
nobody was ever charged with murder, nobody was charged with anything, the case was dismissed. I shouldn't even have to discuss this. At all.
The person that you conspired
I'm
with
not even discussing it.
weren't even charged with the charges you were charged with, correct?
No, so what are we talking about?
Okay, next question.
Mr. Gordon, when you were arrested on March 20th, 2014, the police seized several items or illegal items from your room, correct?
Can't remember, sir, that was 9 years ago.
All right, let me see if I can refresh your recollection. I'm going to show you D76. Take a look at that and see if that refreshes your recollection.
Yes, sir.
It does, right?
Yes, sir.
That list, can I have that back, please? That list lists the marijuana that you were charged with, correct?
Yes.
It lists a bag containing numerous pills, correct?
Correct.
Now, that bag that had those pills that you were charged with, that's not those prescription bottles that the state showed you a picture of, correct? That's different.
I don't know.
Well, this says a bag, those are bottles, correct?
Yes.
And it also talks about the hashish that you were charged with, correct?
Yes, sir.
And there's a scale, grinder, that's the paraphernalia, right?
Yeah.
But there's one thing that's on here, Mr. Gordon, that you were not charged with, correct? Right? 3 clear plastic bags containing white powder, right?
Yes.
That's item number 2, correct? That's item number 2, correct?
Correct.
And that's either heroin or cocaine, correct?
Correct.
That's one charge you also avoided, correct?
Correct.
And you've already told us that the possession of heroin or cocaine is a third-degree crime, correct?
Yes, sir.
Mr. Gordon, very recently, you were again arrested, correct?
Yes.
You were arrested in Bridgewater. Is it township or borough? I don't know. You were arrested in Bridgewater, correct?
Correct.
And on that day, you were charged with shoplifting, correct? The complainant in that case, on the complaint, is the state of New Jersey, correct?
I guess.
So it's the state of New Jersey. Well, I mean, I'll show you the complaint. Showing you D-243. It's the state of New Jersey versus Hassani Gordon, correct?
Yes.
Have you been to court on this yet?
Once, yes. Go back in 2 days. Go back in 2 days.
You go back in 2 days after you finish testifying, correct?
Yes.
So the case is still pending, correct?
Yes.
And I want to talk to you about the day that you brought drugs to court when you were going to testify in this case. Okay? I can't hear you, sir.
Right.
The Middlesex County Prosecutor's Office called you to testify in this case on December 14, 2016, correct?
Correct.
On that day you testified for them, right?
Yeah.
Now you didn't finish your testimony on that day, on the 14th, correct?
Correct.
You have to come back the next day, the 15th, right?
Right.
And you were ordered by the court to show up at 9 o'clock sharp, correct?
Correct.
You showed up over 2 hours late, right?
Right.
You came into this courthouse, into this building, correct?
It's,
Objection sustained. Let's counsel, let's go right to the prior testimony.
Judge, this is not testimony.
Him showing up over 2 hours late,
No.
Mr. Maserati, move on.
But when you showed up, Mr. Gordon, to testify, you had heroin in your pocket, correct?
It was an accident.
You had heroin in your pocket, correct?
It was an accident.
Okay, so you didn't mean to bring it to court,
Yes, sir.
but you still had it in your pocket.
Yes, sir.
And you had over $600 in cash in your pocket as well, correct?
Yes, sir.
You were charged with the possession of heroin, correct?
Yes.
And the possession with intent to distribute heroin, correct?
Yes.
Mr. Gordon, you've given several statements in this case, correct?
Correct.
You've testified several times, correct?
Correct.
You testified on November 1st, 2016, right?
Correct.
I'm going to show you D. '69. When you testified, you swore to tell the truth, correct?
Correct.
And on that day when you testified, in answering questions about your statements, Mr. Gordon, you testified that nothing you had said before was set in stone, correct?
I don't know.
All right. Let's go to page 4117. Actually, hold on a second. Close that up for a sec, please. Just a moment, Judge. Let me see your transcript. That might be different. Get back to this one, Mr. Gordon. Gordon, after you gave your statement in this case on March 20th, you gave it to Detective Danowitz, correct?
Correct.
And Ronaldo Martinez.
Correct.
After you gave your statement, you were released from custody, correct?
Yes.
Our first complaint we talked about was dismissed on March 31st, 2014, right?
Correct.
Due to your cooperation, correct?
Correct.
During the pendency of this case, you had cases, we already talked about that, right?
Right.
You would come for your cases, correct?
Correct.
You would appear in court, right?
Yes, sir.
With your attorney?
Yes, sir.
Now, you made your attorney aware that you were cooperating in this case, correct?
Yes, sir.
You told your attorney to see how he can leverage your testimony as it relates to your charges, correct?
I don't remember that.
You don't remember that? Showing you 237. Flip to page 155.
The D 237?
Yes, ma'am. Look at page 155. Lines 18 to 21. Let me know when you're done reading that.
No.
What was that?
No.
You done reading it?
Yeah.
Can you close that, please? Do you recall telling your attorney, or to see how your attorney can leverage your testimony as it relates to your charges?
Yes, sir.
You told your attorney to let the prosecutor know about your deal with Danowitz, correct?
Correct.
Now, the negotiations continued between you, your attorney, and the Middlesex County Prosecutor's Office, correct?
Correct.
Those conversations, negotiations, whatever they are between all of you, were taking place to basically decide what your future was going to look like, correct?
I guess.
And about how much time you're going to do as a result of your charges, correct?
Yeah.
It all depended on how well you did for the Middlesex County Prosecutor's Office on this stand, correct?
Correct.
On October 13, 2016, you met with the Middlesex County Prosecutor's Office, correct?
Correct.
You were there? Yes?
Yes.
Your attorney was there? Yes?
Yes.
The prosecutors were there?
Yes.
Detective Danowitz was there?
What's your point?
So, it's just a question. Detective Danowitz was there?
Yes, 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 yes.
Just can we be seen at sidebar, please?
Mr. Gordon, just do the best that you can in responding to the questions that are being asked. Next.
On that day, Mr. Gordon, a lot of things were discussed about this case, correct?
Correct.
More things than you had discussed with Detective Danowitz before, correct?
Correct.
That day, you were looking to seal your deal, correct?
Correct.
Now, you knew at the time that in order to seal the deal on your cases that you had to produce, correct?
Correct.
You spoke directly to the prosecutors that day, correct?
Yes, sir.
Negotiating your deal, correct?
Correct.
That relationship that you've had with the Middlesex County Prosecutor's Office, Mr. Gordon, always hinged on your cooperation in this case, correct?
Correct.
have the pages wrong. So, Mr. Gordon, we're talking about your testimony from November 1st, 2016, when you swore to tell the truth, and when you're asked questions about your statements, and you said that nothing in your statement was set in stone. Remember that line of questioning?
No.
Well, I asked you that a few minutes ago. I can ask them all to you again. So, when we were asked questions about your statements, you said nothing is set in stone, correct?
Correct.
Mr. Gordon, you did not see Tim leave the house with a pipe, correct?
No, sir.
You did not see him leave the house with a pipe as long as your leg, correct?
No, sir.
Now, I want to talk about that first statement that you gave on March 20th, 2014. Okay? That was at the police station, yes?
Yes.
The detectives were investigating this case, correct? A homicide case.
Correct.
Very serious case, correct?
Yes.
You knew they were recording your answers, right?
Yes.
They asked you many, many questions, correct?
Yes.
You gave them answers, right?
Yes.
You claimed to have told them the truth, correct?
Correct.
You were helping them solve this crime by telling them what you claimed you knew, correct?
Correct.
Now, you knew they were relying on your answers when you gave that statement, correct?
Correct.
At the end of the statement, or somewhere during the statement, they even asked you if you had anything else to add that you wanted to tell them, correct?
Correct.
And that statement that you gave on March 20th is much closer to the events, correct?
Correct.
But on that day, Mr. Gordon, you were in their custody, right?
Right.
On that day, you were charged with a bunch of crimes, correct?
Correct.
On that day, you had those 3 white bags, whatever was in them, cocaine or heroin, correct?
Correct.
I'm going to show you D10, Mr. Gordon. On page 14, line 15. Question. How do you know he had a pipe? Because I saw. Correct?
Correct.
On page 14, line 21, you're asked to describe the pipe. And you told him it was a pipe as long as your leg, the size of your leg, right? Page 15, line 5,
Yeah.
right? That's what you told him that day, correct?
Correct.
Okay. How tall are you, Mr. Gordon?
6 foot.
6 foot. That's good. Before you testified here, Mr. Gordon, last Thursday, you prepared for your testimony with the prosecutors in this case, correct?
Yes.
You prepared for that testimony shortly before you testified, correct?
Correct.
The day before, a couple of days before? But it was within a day or two, correct?
Yes.
You guess?
Yes.
That was last week, right? Now, during the preparation session, Mr. Gordon, you know, they went over the questions they were going to ask you, correct?
Yes.
And they went over the expected answers to those questions, correct?
Yes.
Now, other than meeting with these prosecutors, did you speak to anyone else before you testified about this case?
Like who?
I'm asking you, I don't know. Did you speak to anyone else about the case? Is what I'm asking, not about.
I don't think so.
Did you
I
speak?
don't think so.
Okay. You mentioned Rob last week. You talked a lot about Rob, Wayne's cousin, right? Rob Sporacco.
Yeah.
Now, you didn't talk to him last week, right?
No.
You haven't talked to him in ages, right?
Yeah, it's been a while. It's been a while.
So, since it's been a while, you didn't talk to him about what he testified about last week, right?
No.
So the only people you talked about this case with last week would be in preparation for your testimony, correct?
Correct.
It would be the prosecutors here, correct?
Correct.
Now, on direct, now I want to pull that board out, Judge, if I may. I'm going to get that board and write some things down, if I may, so I don't lose track. You okay, Judge?
Yes.
All right, Mr. Gordon, I'm going to go over some things with you here that you said on direct examination, okay? On direct examination on Thursday, you said what you claim happened occurred on Valentine's Day into the night, correct?
Correct.
On direct examination, you said that you knew who was left in the house because you can hear people talking downstairs and you recognize their voices, right?
Right.
You said it was Wayne, yes?
Yes.
It was Rob, yes?
Yes.
And you said last week that it was a girl. Remember you mentioned a girl?
Yeah.
Are you talking about Danica Harpster?
Yes.
You mentioned her last week as well, correct?
Yes.
We're going to put her name here. Those are the voices you claim you heard, and that's how you deduced that Mr. Puskas stepped out of the house, right?
Right.
All right. Last week, you said that during the day, everyone was dope sick, correct?
Yeah.
Dope sick meaning you were drawing from heroin, correct?
Correct.
And including you. That's what you said last week, correct?
Correct.
So in order for you to be dope sick, presumably you would have to ingest heroin, correct?
Yes.
That's how you become dope sick. That's what makes you dope sick. If you don't have heroin in your system after a certain amount of time, you get dope sick, right?
Yes, sir.
And you said that you were part of this contingent that was dope sick, correct?
Correct.
So everyone dope sick. And during the day, right? Because of a bad batch. That's what you said, right? And then later on, you said that you guys got more heroin, right?
Correct.
And when you got more heroin, no one was sick anymore, right?
Correct.
More heroin equal not sick anymore, right?
Correct.
And that also, you said, included everybody, right? We're just confirming these things you said, okay? Mr. Gordon, if you could speak up because
Yes.
people need to hear you. Thank you. And we're going to write here that at the time, last week, you said, well, you said a couple of things, but one of the things you said was that at the time, you were using heroin, right?
Yes.
Gordon using heroin at the time. You talked a lot about speedballs last week, remember? A lot of questions were posed to you by the prosecutor about what a speedball is and who does speedballs and the ups and downs of speedballs, right? You said last week that Tim came up to your room and he wanted coke, right? Cocaine. You also said last week that you heard the door open and shut 2 times, right?
Right.
Say that again.
Yes.
You said last week that you didn't keep track of how long Tim was gone for, correct?
Correct.
You said that Tim came back with $40, right?
Right.
You did not tell us the denomination of that $40. It was 2 20s, correct?
I can't tell you. I don't remember.
You don't remember. All right, so we'll write doesn't remember denominations. of money. You said that Tim buys drugs from you, right?
Right.
Not just that day, that's where he gets his drugs from, correct?
Yeah.
You. Right?
Just the cocaine.
You also said that you were still on probation in February 2014. Right?
Right.
You were asked that question twice by the prosecutor, and twice you said you were still on probation in February 2014, correct?
Correct.
Okay, Mr. Gordon. Now, okay. So we're going to start with number one. All right. You said that this was Valentine's Day. You confirmed that just now, right? And you told us, you remembered specifically last week how it was Valentine's Day, right?
Right.
You described how you remembered it was Valentine's Day, right?
Right.
You said that the streets were quiet, right? I can't hear you, sir.
Yeah.
You said that there was no one on the street, right?
Yeah.
You said that there were no cars parked on Hartwell, correct? Yes?
Yeah.
It was quiet, you said, right?
Yeah.
Not only that, you also remembered because your girlfriend was over, correct?
Correct.
And how long had you been dating? That's Jennifer Romero, correct?
Correct.
You had just, how long had you been dating her at the time? New or old relationship?
Yeah.
New?
Yeah.
So you were celebrating Valentine's Day with her, correct?
Correct.
It was a special evening, correct?
Not really.
Not really? New relationship, new girlfriend. You're saying it's not a special evening, not a special occasion.
Not that day.
What was that?
Not that day.
Not that day? You got her chocolate-covered strawberries that day, right?
Right.
You got her flowers, right?
Right.
I now want to talk to you about another statement that you gave in this case, Mr. Gordon. On August 9th, 2016, we interviewed you, the defense interviewed you, correct?
Correct.
You were at this interview with your attorney? Yes?
Yes.
I was there?
Yes.
My investigator was there, right?
Yes.
We talked to you for quite some time, right?
Yes.
You knew we were asking you questions about this case, right?
Right.
Very serious case, right?
Yes.
You knew we were recording your answers, correct?
Yes.
We asked you a lot of questions that day, right?
Right.
And you gave us answers, right?
Right.
Saying, as the police presumably, you knew we were relying on your answers, correct?
Correct.
And we also asked you if you wanted to add anything at the end of that statement, correct?
Correct.
And that statement took place long before you had an opportunity to prepare for your testimony with the prosecutors, correct?
Correct.
It was in fact much closer to this incident, right?
Right.
Showing you D65, page 12, line 19. Do you have a copy?
Yes, thank you.
12, line 19. You see that?
Yeah.
Question. I ask you, is there anything in your mind that sticks in your mind that you did special with your girlfriend that evening? Your answer is no, correct?
Correct.
Now close that. In this statement, Mr. Gordon, you say nothing about how you remember it was Valentine's Day and how it was quiet and how that's how you remember it. You say nothing about that, correct?
Correct.
In fact, when we asked you about what you claim you saw, Mr. Gordon, and when you claim you saw it, you told us that it was close to the Super Bowl, correct?
Correct.
What was that?
Yeah.
And the Super Bowl that year was played on February 2nd, 2014, correct?
Correct.
Now, I want to talk to you about the March 20th statement when you were discussing with the officers what day this was. Okay? D10 for identification, sir. Page 17. Before you look at that, you do acknowledge that Valentine's Day was on a Friday, correct? On that year?
Yeah.
So looking at page 17, line 12. To 17. You tell the detectives on line 17, when they're asking you about what you claim you saw, that I believe since it was a Saturday night, correct?
Correct.
Now let's go to page 23 of that same statement, Mr. Gordon. And this is a statement that you gave just a little over 30 days after you claim you saw this stuff. Page 23, line 21. Question. Can I ask you something? The night that Saturday that you described him leaving, as you said, that's the detective asking you about him leaving on a Saturday, correct?
Correct.
Repeating the answer you gave them earlier, correct?
Correct.
They're asking you in that same question, who else was at the house, right? Correct? On the next page, just up to line 8, correct?
Yeah.
You were telling them, presumably, about what you're telling us here today was on Valentine's Day, correct? Close that transcript, please. Close it, please. You were telling them back then that it was Saturday night, and you told them who was at the house, correct?
Correct.
Again, Mr. Gordon, showing you your testimony. This is another document in which you talked about the day. Okay? So, This is a testimony from November 1st, 2016, correct? Sworn testimony, right?
Yeah.
Mr. Gordon, the jurors cannot hear you in the back.
Yes.
And that sworn testimony, on that day, Mr. Gordon, you put your hand on the Bible, right? Right?
Right.
It was a hearing that we were doing, and you looked at all of us and you swore to tell us the truth, correct?
Correct.
D69, page 29, line 12. You ready?
Yeah.
Question. And what we mean by Saturday night is that Saturday day had already passed and we went into Saturday night and the next would be Sunday. That's what you mean by Saturday night. Your answer on line 16, yeah. Correct?
Correct.
Again, you're asked on 17, well, I just want to be clear on it, okay? Right? And your answer is on 19, yeah. Question. On 20, yes? Your answer is yes, I guess. Correct?
Correct.
We have that? Again, much closer to the time, right?
Correct.
Now, we touched on this a little bit just a minute ago about who was at the house, right?
Right.
On the rec, you said it was Wayne, Rob, and Danica that night, correct? Yes?
I said a female. I wasn't sure if it was Danica, could have been Ashley. It was a female.
You're not sure if it was Danica, although you did confirm with me it was Danica before, correct?
One time.
Well, a female, you said, right?
That's what I said.
Okay. So I'm going to show you D10. Again, that's shortly a month after you gave that statement, after the incident. The D10 is your March 20th statement to police, correct? And they asked you who else was there. Page 23, line 21. Can I ask you something? The night, that Saturday night that you described him leaving, and you said your answer is on line 2, shit like that. Question. All right, who else was there with you? Answer. With me? Question. On line 5. Who else was in the house? Answer on line 7. There was at least Wayne and his cousin. At least Wayne and his cousin. Question. Who's his cousin? Answer. Rob. His name's Rob. I don't know his last name. Question. That's definitely. Answer. That's those two. Question. Wayne's cousin. Answer. We're there. Okay. Who else? I don't know is your answer if Ashley and her boyfriend Danny were there, but... And here you talk about Ashley, correct?
Correct.
And on the next page, you tell them, on line 1, you're not sure if Ashley and her boyfriend were there, correct?
Correct.
Nowhere in here do you mention Danica, right? Correct? Am I correct?
Correct.
So, let me see that, please. I'm going to show you D-236, which is the transcript of the December 14, 2016 testimony under oath. .318, line 15. Actually, line 13. You ready? 318, line 13. All right? Okay. Question. You didn't see Danica that night, correct? No. She could have been there, but no. Question on line 15. But you didn't see her. Answer. No. Question. You didn't see her hanging out downstairs having dinner with Wayne and Tim and Rob, correct? Answer. No. Correct? Okay, but that's the question, questions and answers, right? I read it right, correct? Now close that for a second. Close it, please. And if you need to go back to it to look at it, nowhere in that transcript, Mr. Gordon, do you ever say you heard Danica talking downstairs, correct?
Correct.
Ma'am. Thank you. All right. So let's first talk about where you say everybody in the house was dope sick that day, okay?
Okay.
And again, to confirm, dope sick means one thing and one thing only, right? We're drawing from heroin.
Yep.
That's what we're talking about here, right?
Yes, sir.
So I want to focus about Tim right now. We'll get back to everybody else. I'm going to show you D10. Again, which is the statement you gave to the police. Go ahead. Nowhere in there do you say anything about anyone being dope sick, correct? Correct? Where? Tim wasn't feeling well, he does dope, I guess he was sick. Whatever, at the time, correct?
Correct.
You say nothing about anyone else being dope sick in this statement, correct?
You gotta continue looking at this.
Go ahead. Not in there, right? Make sure. Nothing in there about that, right? Can we see that again? So nothing in there about you using dope, correct? Nothing in there about everybody being dope sick, correct?
Correct.
You say that Tim wasn't feeling well. He does dope. Let's get your exact words. And I guess he was sick, correct? You were guessing that he was sick, right? That's what you said here, correct?
Correct.
And in fact, a few pages later, on page 13, line 4, Mr. Gordon, you tell the police that everybody was high as hell that night, correct? And what you mean by everybody, it means everybody, correct?
Yes.
You, right?
Yes.
Tim, Wayne,
Yeah.
Rob.
Yeah.
Presumably, Mr. Gordon, if Tim was high as hell, he wouldn't have been dope sick, correct?
I did say we ended up getting dope later on that night.
It's not in this statement, correct? Mr. Gordon, it's not in this statement, correct?
No, not testing.
Showing you D69, Mr. Gordon. This is the testimony from November 1st, 2016. Nowhere in there do you say that you were dope sick, correct? Nowhere in there do you say that you were dope sick.
I'm pretty sure I did, sir.
Thank you.
Okay, we have jurors indicating they need a bathroom break, so we're gonna take our mid-morning recess. Please don't talk about the case. We'll see you back in about 15 minutes.
You were reviewing the transcript to see if anywhere in there you said that you were dope sick. My question to you was, nowhere in there, in the November 1st, 2016 sworn testimony under oath, did you say that you were dope sick, correct?
Correct.
Nothing in there about Wayne being dope sick, correct?
Correct.
Nothing in there about Rob being dope sick, correct?
Correct.
You gotta speak up, please.
Correct.
You said on direct examination that you had a bad batch, or you got a bad batch of heroin, correct?
Correct.
Can you close that, please? We're done with that transcript. Thank you. Showing you D10, which is the statement that you gave to the police on March 20th, 2014. There's nothing in there about getting a bad batch of heroin and getting sick, correct? That one you already reviewed.
Correct.
There's nothing in there, actually, let me see that one, please. Now showing you D65. This is the statement you gave to us. August 9th, 2016. There's nothing in there about you guys getting a bad batch of heroin and getting dope sick, correct? November 1st, 2016, your sworn testimony as it relates to what you claim you saw or what you claim happened. There's nothing in there about getting a bad batch of heroin and getting dope sick, correct?
is there an area where he would have been questioned about it that you can direct the witness to, rather than reading the entire,
No, Judge, because I don't want to make comments on the record. I can talk to you at sidebar.
yeah, we need to move this along.
Mr. Gordon, the page you're pointing to, page 34, talks about Mr. Puskas having the sweats, correct? I asked you about a bad batch of heroin that day. That's what I asked you about. There's nothing in there about you guys getting a bad batch of heroin, correct? Very specific question, Mr. Gordon. Thank you.
Page 36.
Again, you were talking about Mr. Puskas withdrawing from heroin here, correct?
Yes.
But I asked you about a bad batch. That's not in there, correct? It's a very simple question.
Speaks about being sick. It doesn't say bad.
And I didn't ask you about that. I asked you about this bad batch that you claimed on direct you got. That's all I asked you about.
Okay.
It's not in there, correct? Let me ask you this question. When you prepared for your testimony with the prosecutor, didn't they give you, or even before, didn't they give you the statements that you gave so you can review them?
I guess.
So they did, correct? Yes?
Yeah.
All right. So they gave you the papers that you're reading today to look at, correct?
I guess.
And I assume that you looked at them before you testified, correct?
No.
You did. All right, can I have that transcript, please? So you told us a lot about how you use heroin, right?
Right.
When you were sentenced on March 24th, 2017, for your two cases that we talked about, remember that?
Yeah.
Before you were sentenced, you met with a probation officer, correct? for an interview, Mr. Gordon. The pre-sentence interview. Remember that?
No. It's a long time ago.
During that interview, you were asked many questions before you were sentenced, correct?
I guess.
You were told that you had to tell the truth, correct?
Yes.
You were asked questions about, your age, your date of birth, right?
Right.
Your family members, correct?
Correct.
Your employment status, correct?
Correct.
Your drug use, correct?
Correct.
About the facts of the case that you were going to be sentenced about, right?
Right.
You were asked all kinds of things, all kinds of questions, right?
Right.
Now that interview is reduced to a report that is ultimately forwarded to you, right? Yes?
I guess.
To your lawyer, right?
I don't know. What's the point?
To the judge.
What are you saying?
He doesn't know.
I don't know what you're
Move
talking
on,
about.
move on, stop, move on.
When you appeared for sentencing, Mr. Gordon, you appeared with your attorney, right?
Correct.
And you were asked, are there any additions, corrections, or deletions to the pre-sentence report? You remember that happening?
No.
All right, let me see if I can refresh your recollection.
Let me see it inside. Next question.
Mr. Gordon, you talked a lot about this speedball that you claim that you saw Tim Puskas do, correct?
Correct.
And that's what you're telling us there, Mr. Gordon, is that you want us to believe, Mr. Gordon, is that that's why Tim came to you for cocaine, correct?
I don't want you to believe anything. That's what he did daily. Numerous times.
I'm asking you a question, Mr. Gordon,
I hear you.
okay? That's what you were saying to us,
That's what I
correct?
said.
Well, that's what you said, correct? That he came to you looking for cocaine
Every day.
so he can use this,
Every
so
day.
he can do a speedball, correct?
Daily.
Every day.
Every day.
Every day. So, showing you D10 again, Mr. Gordon. That's the March 20th, 2014 statement. And that statement you gave a long, long time ago, correct?
Yeah.
Before you prepared for your testimony for this case, correct?
Yeah.
Now, nowhere in there do you say anything about speedballs,
I don't
correct?
have to. Nobody
Nowhere in
asked-
there
I
do you
wasn't
say
asked that
anything
question.
about
I
speedballs,
wasn't
correct?
asked that question. I didn't have to bring that up.
So the answer is no.
I guess not.
So the answer is no.
But he did speedballs every day.
Is that in there?
It doesn't have to be. It's a fact.
Is that in the statement,
It's
Mr.
not.
Gordon?
No.
Thank you. You see that? August 9th, 2016 statement. Is it anywhere in that statement?
You don't have to be.
Is it anywhere in that
It
statement?
doesn't have to be.
Is it
It's
in there,
not.
Mr. Gordon?
It's
It's not, move on.
November 1st, 2016 testimony. Nowhere in there does it say anything about speedballs, correct?
Nope.
I'm going to show you D240. This is the most recent statement that you gave to the Middlesex County Prosecutor's Office on October 20th, 2021. 66-page statement, correct? Take a look.
I don't have to.
66-page statement, correct?
Let's assume it's 66 pages and ask the next question.
You were asked a lot of questions on that day, correct?
Yeah,
You answered those questions, correct?
correct,
And you answered them, you claim truthfully, correct?
correct,
Those questions were being asked by the Middlesex County Prosecutor's Office, correct?
correct.
Now, nowhere in that statement do you say anything about speedballs, correct?
If they didn't ask me about it, I didn't say anything.
Nowhere in that statement do you say anything about speedballs, correct?
Did they ask me about it?
They asked you a lot of questions,
The
Mr. Gordon.
question was answered, and the question was not asked, and he did not provide that information. Next.
But they did ask you a lot of questions about drug use, right?
They didn't ask me about a speedball.
They asked you a lot of questions about drug use, correct?
About a speedball, though. You're asking me about a speedball.
Mr. Gordon, did they ask you a lot of questions about drug use?
Mr. Maserati,
Your Honor,
Let's move on. Let us please move on. The question has been responded to. Next question.
Well, Mr. Gordon, when a person is dope sick, you already told us that you need to get more heroin in your body in order to stave off the sickness, correct?
yes.
And that's what would make a person no longer dope sick, correct?
Correct.
Cocaine is not going to make them no longer dope sick. Has to be heroin, correct?
For about 20 minutes after you do cocaine, you'll be fine. After the 20 minutes, you'll be extremely sick.
Extremely sick. So in order to stave off this extreme sickness of dope sickness, you need heroin, correct?
Correct.
You're even more sick if you do that little bit of cocaine, or if you do cocaine after that 20 minutes than you were before, correct?
Correct.
That's because cocaine is an upper, correct?
Correct.
So you need heroin in order to no longer be dope sick, correct?
Correct.
So that night that you claim Tim came up to your room and got cocaine, you are saying he did that so he can do a speedball, correct?
Or just do cocaine.
Or just do cocaine, right?
Right.
And from what you just told us about not doing cocaine when you're dope sick, he would have had to come up not being dope sick, correct?
Yes.
So when he came up, what you're telling us today, and what you told us on Thursday, is when he came up to your room that day, he was not dope sick, correct?
Not anymore.
That's the question, sir. He was not dope sick when he was at your room door, correct?
We got good dope, and we were all fine.
All right. So the answer to my question, when he came up to get cocaine, he was not dope sick, correct? Correct.
Correct.
All right. I'm going to show you D69. This is a transcript of your testimony from November 1st, 2016. On page 61. Page 76. One of the things that happens when a person is dope sick, Mr. Gordon, is that they sweat profusely, correct?
Yeah.
They get the sweats, right?
Yes.
So I'm going to show you page 34. As it relates to your observations of Mr. Puskas. See that?
Yes, sir.
And you were describing there on page 34 how Tim was dope sick on the day that you claimed this occurred, correct?
Yes.
There's nothing in there about this being earlier in the day or later in the day, correct? You were talking about all day in this transcript, correct?
I believe
You can look at it, Mr. Gordon.
I gave you the times, man. We were sick when we woke up. We ended up getting good dope.
That's what you said on direct
This incident
examination.
happened after that.
That's what you said on direct examination. I'm talking about what you said on a prior occasion, Mr. Gordon. You, on a prior occasion, you described Mr. Puskas as being dope sick
He was,
all
we
day.
know it.
On a prior
When we
occasion,
woke up, we
Hold
were
on,
all
hold on,
upset.
hold on. Ask your question.
on a prior occasion, Mr. Gordon, when we asked you about this, you indicated that he was going through withdrawal
He
all
was.
day. Okay? And that's what I'm asking you. That's what it says in this transcript,
Yes,
correct?
yes.
It says nothing about you guys were sick in the morning or during the day, you got dope, and then everybody was fine, correct? Doesn't say that, correct?
I don't know what it says, but I'm pretty sure that I told you the times when we woke up, we were sick. We didn't have good dope. After that, we got good dope, and then you wanted coke.
Mr. Gordon,
What do you-
that's what you said on direct examination, right?
That's,
In prior testimony, you did not say that, correct?
I don't know, sir.
Here you go. Take a look. Take a look, sir.
I don't have to.
let's,
I know what happened.
Judge,
that's his answer, that
I
is
know
his
what
answer,
happened.
please, let's move
Go
on.
ahead.
Let's
Judge,
move
can I
on.
be seen at sidebar, please?
Let's move on, counsel, please.
Judge, I'd
Ask
like
your
to
next
address the
question.
court.
Allow you to make your appropriate record, move on to your next line of questioning, please.
All right, I'm going to show you the latest statement that you gave, Mr. Gordon. 240,
I know what I said.
D240, Mr. Gordon. Let's go to page 29, line 18. Line 18, Mr. Gordon.
I don't have
Judge, may we be seen at
29
sidebar, please?
29, Mr. Gordon, go to page 29, line 18. What's your question?
You see that, Mr. Gordon?
Yeah.
This is the statement that you just gave, where you were asked a lot of questions about drug use, yes?
Yes.
So on page 29, line 18, so you're asked, so correct me if I'm wrong, withdrawing, your answer, yes, he was dope sick. Question, how did you know he was dope sick? Because we all were. I was doing dope at the time too, and no one was around, correct? And when you're saying no one was around there, you're saying to the police that no one was around to get dope from, correct?
Correct.
So that means on October 20th, 2021, Mr. Gordon, you did not get more dope, according to this statement,
Yes,
correct?
we did. Yes, we did.
All right.
Yes, we did.
Well, look at the statement and tell me where it says that.
I don't have to look at this statement.
Again, Judge, I'm asking to be seen. I'm asking to be seen, Judge.
We're going to take our lunch recess at this time. Please, members of the jury, don't talk about this case. We'll see you back in an hour. We all are just trying to get through this, including you. You have to listen to the questions and answer the questions to the best of your ability. This may be frustrating for you. It's frustrating for everyone here if we can't get through this. Let's get through this so that you don't have to continue to come back, all right? So let's be back in an hour. So we are on the record in the matter of State of New Jersey versus Timothy Puskas. As we were breaking before the lunch hour, I'm pretty sure everybody realized that there was a knock at the door and there was an indication, I guess, by one of the jurors that it was loud in the room where we were discussing counsel's request to be heard. So I just want to remind everyone that while the white noise is on, it's only going to carry, but so far, if you start raising your voices as we're having our sidebar, you would lower your voices if you were here in the courtroom. I ask just that you continue to do so in the room to avoid any potential that the jury is going to hear what's being said. So we can bring Mr. Gordon in. Mr. Rosrani, you asked before the lunch hour for an order specifically because you felt as though the court was limiting your ability to cross-examine this witness.
As far as I've seen your evidence.
I'm going to withdraw that application now, but I have another. I don't need an order. Judge, at this point, unfortunately, I'm compelled to ask for a mistrial for several reasons. This case, it rises and falls on that witness. And and please don't take this the wrong way, I have to make my record here. He's controlling the courtroom. He's controlling the courtroom because the court's allowing him to control the courtroom. And I know why the court's doing that, because the court wants to get him out of here. I get that. I completely understand. I completely empathize. I get you want to get him out of here. And his antics are controlling these proceedings. He's the only glimmer, if you will, that the state has in this case, because there's this new theory of my client was, well, now it's no longer withdrawing from heroin, right? Now it's wanting to do a speedball, because the withdrawal from heroin doesn't work anymore, because Robert Sparacco testified that you don't do cocaine when you're withdrawing from heroin. And I know the court is following my cross-examination, and that's where I'm going with this, but this man has basically taken control of this courtroom because of his antics and because of the court's desire to move things along, and that's come to the detriment of Mr. Puskas. It's come to the detriment of Mr. Puskas in many ways. On direct examination, Mr. Gordon knows all kinds of information. Just because he doesn't say he doesn't know when I'm asking him questions doesn't mean
I'm not entitled to take the time I need to show that he in fact does know, and he's just acting the way he's acting because he is who he is. And I brought this to the attention of the court long before this trial started, and I even asked you, and I continue to ask you, even today, please, Judge, show him that there is order in this courtroom. What end up happening here is you're coming down on me because I'm an attorney, we see kind of at the same level, you know, you're a judge, there are attorneys here, you're coming down on me and telling me to move on and speed things along because maybe I'm capable of doing it and he's not. But what's happened, Judge, here is that the jury sees you coming down on me, and they see this guy throwing a statement at me. That's the last thing he did, right? He refused. We got to the point with him, and if you could probably see the progression. Initially, I had some control over him, but that last outburst, he refuses to look in a transcript. That's basic cross-examination. He has become unavailable for cross-examination. Hassani Gordon has become unavailable for me to cross-examine him because he refuses to look at a transcript. Now, I know that demeanor, okay, but demeanor is just one factor. Prior inconsistent statements are a major factor, which brings me to the very important impeachments that I wanted to do. The man lies through his teeth about everything. He denies, the reason he says the cases were dismissed is because he denies that he sold the drugs. I have evidence that he sold the drugs. I go to confront him with that, you shut me down. Fine, I let that go. That wasn't, I'm like, you know what, the jury heard enough, let me move on from that. But a very important impeachment, a very, very important impeachment is that this man sells heroin. He does not do heroin. And he's selling this new story now that everybody was dope sick. That he was dope sick along with everybody when for years he's maintained that he does not use heroin. He said that to the pre-sentence investigator. He even said it in court on direct examination, and the state had to correct him. And I'll show you where in the transcript. The state asked him, when did you start using heroin? And he said to the state, in 2015, maybe the end of 2014. But a few questions later, it was now in February 2014. I need to be able to show that that man is lying about his use of heroin. And that is important for my theory of the case. And I'm not even able to complete an impeachment because we want to get him in and out. And I understand, and I'm sorry, but he's been rendered unavailable, and that's to the detriment of Mr. Puskas, Judge. So when you come down on me repeatedly to move on, and I get that, sometimes you have to, right? But repeatedly you've come down on me to move on, and he sees that. He sees you doing that. So it empowers him more. And I know you're not doing it maliciously. I know you're not doing it for bad reasons. You're doing it because you want to get him off the stand. But he sees you coming down on me, and so does the jury, and he acts the way he acts. And he acts the way he acted, and it progressed. We can go back. I mean, obviously, I tried to put some things on the record throughout, but we could probably reconstruct to see how he was last week, how he was this morning, and how when you started saying to me, move on from perfectly good things, perfectly things that I'm permitted to do, just because we want to get him out of here, that he's been empowered. Not purposely, obviously, but that's what he sees. And that's a concern has always been of mine with this witness. He is a clown. And with that last outburst there, what's the jury think? You yell at me, he throws the statement down, and then we go in there and we're having a discussion about his behavior. The jury now thinks that I'm playing games, right? When I'm actually doing textbook impeachments, they take long. I know they do. I know they do. I know they do, and I know they're painful, and I know they suck sometimes, but I have to be able to elicit information that I need for my theory of my case. It's not just the state. And that is to the detriment of Mr. Puskas. So the jury sees you coming down on me. He's acting more, he's more brazen because, Obviously we have a relationship, right? I appear before you. You can talk to me that way. He doesn't know that, So this whole circus that man has caused is no fault of yours. It's no fault of the state's. I mean, the state's not even objecting to these questions. You're so frustrated, Judge, at least it appears to me, because of the way he's acting, that you want to move things along, that at the end of the day, the brunt is on Puskas, not on you or me or the state. Like some of these questions, the state didn't object to. When I was talking to him, building up the accreditation for what he told the probation officer during his pre-sentence review, you cut me off on a very important issue. And the jury probably believes, and I would submit to you, they do, that I'm playing games. That's what it looks like. So, I don't even know how we can fix this at this point, Judge. I don't even know how, not one time did you say to him, stop acting up. Not one time. In fact, you're so kind to him, and I know you're trying to diffuse the situation, and I know you have the sheriff's officer up there to diffuse the situation, but he needs to know you are also the boss of the witness, not just the boss of the attorneys. So he doesn't know that. He's been able to do what he wants. Talk the way he wants. He's talking smack the whole time he's up there. He's mumbling under his breath, and I'm ignoring him, But when he threw the statement, Judge, that's a new one for me. That's a new one for me. Because he got caught in a lie. Because in the statement, he says to the detectives, we were all looking for heroin. When this whole new version now about they were looking for heroin only in the morning because they were dope sick, and then they weren't dope sick anymore. Why? Because people who are dope sick, Judge, don't do cocaine. And the state knows it has a problem with that. Even he said you don't do cocaine when you're dope sick. So clearly, you can't be dope sick anymore if you want to go get cocaine. So, I mean, it's, and I can't even elicit that impeachment from this guy? Then how do that's the state's theory, so they get to advance their theory, but Mr. Puskas doesn't, because Hassani Gordon has taken control of this courtroom. And I don't think there's any way to turn it back, Judge.
Thank you, Your Honor. First, I'd like to place on the record, I believe counsel started out with asking for a mistrial. I believe that there is no reason here, Your Honor, for a mistrial for the following reasons. One, counsel has had ample opportunity to engage in cross-examination of this witness. The state has many times on the record objected, stood up to almost object, whereas the court, knowing the rules, understands the objection immediately. Asked and answered has happened so many times in this proceeding for cross-examination that at this point, Your Honor, it is at a point where it is becoming almost to the state's belief, almost a cause to want to delay this proceeding. We are here, Your Honor, where we have tried our best. I don't see any attempt, and I like to place this on the record, of anyone trying to get this witness on or off so that we can hurry up this proceeding at all. Absolutely not. It's quite the contrary. What we don't want to do here, which I thought everyone's goal was, is to not cause a mistrial, to not have a mistrial. But it seems that counsel continuously looks for ways, even through the questioning of certain transcripts and trying to bring to the attention that everybody at this point who's testified prior has testified in a prior proceeding all around the same days, which would indicate there was a prior trial. But it appears counsel is looking for any attempt in order to cause a mistrial here, which again, Your Honor, the state believes there is no basis for. Again, the state has made many objections here. When we were on the record, and I'd like to place this on the record, while we were at sidebar last, counsel, as the state tried to engage in the conversation, counsel turned to the state, pointed his finger, and stated specifically, I don't want to hear from you, while pointing and yelling at the state directly. That should be placed on the record. So again, the only bad behavior that the state is viewing right now is counsel, and it is inappropriate. So at this point, Your Honor, the state does not believe that there's any reason to have a mistrial. The witness is out in the hallway. We warned him, as the court has. We've had to please listen, be respectful of the rules, make sure not to mention the prior trial, make sure not to mention anything about the hammer, make sure not to mention anything about anything that we've already discussed, and let's get through this appropriately within the bounds of the rules.
You know, Judge, just briefly, you know what, I don't want to hear from the state, because every time I try to speak in there, and I want to put that on the record, the state cuts me off. And I think at one point last week, you said to the state, stop and let him finish. Because every time I'm inside, I have to stop, because the state cuts me off. And that's been happening throughout this entire case. And I've tried to be patient and patient and patient, but at the end of the day, I'm asking this court to take control, not just of the defense, but also of the state. Number two, I want a mistrial. This guy's been sitting in jail for 10 years on these ridiculous charges. Ridiculous. I want a mistrial. And I'm asking about prior proceedings. What do I do? Well, how do I ask? I listened to you. I said, you said to me, don't talk too much about who questioned you, who did. I stopped. I listened to you. I stopped. I said, prior proceedings, sworn testimony under oath, and I'm moving on. But I want a mistrial.
So listen, there's a lot of tension in this room. I just need you all to take a deep breath and recognize that nobody wants to do this again, right? But I will never, in my quest to not have to do this again, preclude either one of you from making an appropriate record. And so whenever it's the state, as you've indicated, cutting you off as you're making arguments, I've said to the state, I can't let him finish and make his arguments. So both sides recognize that I've listened to both of you. You have access and the ability to know what it is you expect from the witnesses. I have some limited availability based on the fact that this case has been tried before. However, cases get tried very differently when they come back and they have to be retried again. So you know specifically what it is you want to get from certain witnesses and why you want to get certain information from certain witnesses. And I have been more than patient in allowing you both to express what you believe is your respective position. Now, to be clear, you know, this notion that I'm trying to hurry this witness off the stand, if at any point in time the court says move on, it's move on not because it is the court's attempt to get the witness on and off the stand hurriedly and preclude counsel from doing his job in effectively cross-examining the witness. It is because much of what is being asked are things that, at least from this court's perspective, whether it's my notes or whether it's my own independent recollection of what I heard, it seems as if there are things that I was hearing repeatedly. And so if I was asking to move on, it was because the witness may have responded to a particular question, and although counsel may not have liked the response, or he didn't respond in the way that one had hoped, it was the court's intention to simply move it on. So there have been cases out there that describes the court's responsibility to act as the gatekeeper. I'm not sitting here as a potted plant. That's actually in a case out there. So I have a role, I have a function here. And were there, more specifically with respect to the line of cross-examination, was there a point at which the court asked to see counsel at sidebar without a specific objection coming from the state? And I'll note there were times that the state was slow in getting up to make the objection. It was clear that the objection was coming, and quite frankly, there were points at which I did not want anything to be said that I now had to fix because it had already been said. And so my hope was to get ahead of it before anything could be said, especially when we're dealing with, everybody recognizes, a witness who knows what's going to come out of his mouth according to what his behavior has been in the past. Now, the idea that the court was cutting counsel off in his ability to cross-examine on the issue of heroin. So through the arguments that were just presented, it seems to me that there are ways in which the witness could answer the questions that counsel is seeking to get answers to without reference to a, something he would have said to a probation officer. So counsel has the ability to certainly cross-examine on prior inconsistent statements, and when there is an attempt to do so, the court has to, there has to be some indication that whatever prior statement was given was, there was some indicia of reliability such that the jury can truly find that in fact there was either a prior inconsistent statement or omission or otherwise. So here, we're talking about some reference to a question that may have been posed by the probation officer in preparing the pre-sentence report. We don't know the specifics of that conversation. We don't know why the response was what the response was. There's a whole host of reasons we don't start now allowing cross-examination about any and any time somebody may have said something different than they said here today. I've heard some reference to testimony given previously with regard to this very issue. That certainly is a subject area for cross-examination. But to now get into conversations between he and the probation officer, so when the pre-sentence report that was being prepared, I don't find that to be a proper way to conduct impeachment cross-examination. And so while I can recognize that we can all perhaps agree to disagree, but that's my understanding of how the rules work. And so anytime I say move on, it is because it is my attempt to, in fact, indicate that the question is either not appropriately asked or the witness has already responded, although the response may not have been in a manner that was either expected or wanted, whatever word you want to use. At the end of the day, that's the court's attempt. And so, you know, Rule 611 sort of gives the court the ability to control how these proceedings work. And as I indicated to counsel in the back, there's been too many news stories about crazy things that happen in courtrooms. The way this courtroom is set up is such that the jury is very close to the witness box, and when counsel is in between the witness and the jury, there's really not a whole lot of room there for an officer to really maneuver and make sure things don't go left. To the extent that what is being said is that somehow this case is now, the witness rather, is being progressively emboldened by the court's refusal to sort of rein him in. It seems to me that to the extent that the witness is getting frustrated, this court is somewhat frustrated by sometimes questions that are the same questions, and they're being asked over and over and over again, and at some point, you know, somebody's gonna get frustrated if you're continually asked the same question. And listen, I have before me now a motion for a mistrial. It is not one that I find that is appropriately granted at this time. We're gonna bring Mr. Gordon in, and to the extent that, well, let me I indicated to counsel in the back, and I'll say it here again, I did not see him throw a statement. I'm not suggesting that you're not being honest with the court about that representation if you say that that's what in fact happened. Mr. Gordon will be brought in, and I will make it clear under no uncertain terms is there to be conduct like that as we move forward. But again, I'm going to implore counsel to do your best in terms of succinctly asking the questions that need to be asked. I will tell you as someone who didn't sit in this trial as others did, at the end of the day, it seems to me the point has been made that this witness, through cross-examination, gave a number of different versions that are not consistent with the version that he gave. What's before this jury is that this witness has a record, a mile long. What is before this jury is the fact that this witness had matters for which he faced significant consequences and did not because of his cooperation with the state. In this court's mind, it doesn't get a whole lot better than that. So that's from my humble perspective in terms of what counsel feels is an inability to effectively cross-examine. Folks conduct cross-examination on a regular basis around in courtrooms around the state every day. And we don't always get a witness who has, you can check off all those boxes. And Mr. Gordon, inconsistent statements, prior records, cooperations, dismissal, you name it, it's all there and it's all out before this jury. So it seems to me that he has been more than effectively cross-examined. At some point, however, we need to cut it off.
Judge, I appreciate that, but cutting it off because the court feels he's been.
No, cutting it off because you're asking the same questions, that's why.
I appreciate the ruling, Judge, thank you. As it relates to the issue of his heroin use, again, Judge, courts rely on those pre-sentence reports. And in order for me to complete the impeachment, I have to ask him whether he said that. Because if he says yes, then fine. If he says no, I did not say that. I did not say I don't use heroin. Under 613B, I'm entitled to bring in the probation officer to have her complete the impeachment. It's extrinsic evidence of an inconsistent statement. These things may be little points to the court, Judge, but it's important for my theory of the case. He's never said he used heroin. This is new. And
that is in a statement that he gave already, or prior
no,
testimony
that's the new statement. The new statement he says he did, but before.
And he's never said that before.
I understand that.
Correct.
But
I've made my ruling in that regard, and certainly if your client is convicted, that's point one of your appellate brief. That's my ruling.
okay, Judge.
Bring in Mr. Mr. Gordon, we're gonna, in a minute, bring in the jury, right? I wanna remind you, right, this is still a courtroom, and we have a certain level of decorum that we need to maintain. And so it came to my attention that you tossed a statement. Was it your intention to toss that at the defense counsel? Regardless of whether you intended to toss it at him or any place else, do not engage in that type of behavior, understood? Don't put yourself in a position where now you are going to face being held in contempt because you're not complying with the court's orders, understood? That's a yes? Bring in the jury, please.
The line on
Thank you, be seated.
We left off, we were talking about your claims that you were a heroin user in February 2014, correct? And that you were dope sick with everybody else from a bad batch of heroin. And then you got heroin and you did heroin, and then you were no longer sick, correct? Now, you testified here on last Thursday, under oath, right? Just the other day, correct? Yes?
Yes.
And you were asked that question. I'm showing you D238 on page 16. Line 8 of your sworn testimony, where you looked us all in the eye, told us you were telling the truth. You were asked the question by the prosecutor. All right. And when did you begin, to your knowledge, using heroin? Your answer on line 10, and this is just a couple days ago. 2015, or maybe the end of 2014, probably. I read that right, correct? Can I have that? And that was your answer about when you started using heroin that you gave to the prosecutor, correct? You told us before the break that a person withdrawing from heroin is not going to do cocaine, correct? Because they're going to get really sick. That's what you said, right? And I was talking to you about Tim's condition that day. And I was showing you transcripts about his condition. And let me go back to that, Mr. Gordon. D69. Page 61. And D69 is your testimony from November 1st, 2016, correct? Sir, I can't hear you.
Correct.
And that's under oath, correct?
Yes.
Question. Line 3. How would you describe it? Answer. Your answer on line 4. It looked like he had the flu. He didn't have the flu, but he looked like he had the flu. Sweating, he didn't get out of his room, he was sleeping all day. Question, on line 8. And did you describe that to us as being what you thought was dope sick? Your answer on line 10, yes, yes. Correct?
Correct.
You're describing Tim here, correct?
Correct.
Page 76, line 24. Did you tell the prosecutor on cross-examine or on cross that Tim was sweating and he was sick that day? The answer on line 77, yeah. Question, that he had the flu and he looked like he had the flu. Answer on line 4, I said he was dope sick. Now, Mr. Gordon, May I? In your latest statement, before you testified, and before you were prepared for your testimony, that statement that you gave on November 21st, 2021, you told the detectives repeatedly that when Tim came to your room looking for cocaine, he was withdrawing from heroin, correct?
Correct.
He was dope sick, coming for cocaine, is what you told the detectives on November 21st, 2021, correct?
Correct.
Now, nothing in that statement, Mr. Gordon, about this break of everybody's withdrawing because you had a bad batch, and then later on, everybody's not sick anymore, correct?
Correct.
In fact, in that statement, Mr. Gordon, you told the detectives that there was no heroin around that day. That you guys were all looking for it, correct?
Correct.
So, this idea, or this testimony that came up last week about the fact that you guys did get heroin later on in the day, that's not what you said on October 21st, 2021, correct?
Correct.
Now that day, when Tim was sick and withdrawing from heroin, Mr. Gordon, you described what he looked like, right? Yes?
Yes.
That he wasn't feeling well, correct?
Correct.
That he was home all day, correct?
Correct.
That he looked like he had the flu. Yes?
Yes.
That he was sweating profusely. Yeah?
Yeah.
He did not get out of his room all day, correct?
Correct.
He was in his bed all day, correct?
Correct.
He was sleeping all day, correct?
Lower.
Huh?
Lower.
So the answer to my question that Tim was sleeping all day is correct, right?
Correct.
And you know this, Mr. Gordon, because you saw him in the house all day, correct?
Correct.
And that also helps you remember that that's the day you claim he left the house, correct?
Where is the day left?
That helps you remember, correct?
It doesn't help me remember.
Okay, well, I'm going to show you 12:14 here. D236. Page 322. Actually, let's start at 321, Mr. Gordon. Line 18, question. And you know this because you saw him home all day, yes? Your answer on line 20, yes. Question, line 21. And you indicated that he was in bed all day, correct? Answer on line 23, yes. Line 24, question. That he was not feeling well or sick, correct? Your answer on page 322, line 1, yes. Question, and that he was sweating profusely that day, correct? Your answer on line 4, yes. 5, question, so he was laying in bed that day, yes? Answer, yes. Question on line 8, and that also helps you remember that particular day, correct? And your answer is yes on line 10, correct? May I, sir? Showing you D10, as you said, Tim came up to your room wanting Coke. This is your March 20th, 2014 statement. You say nothing in there about Tim coming up to your room that night wanting Coke, correct?
I don't know.
You had an opportunity to review that before. There's nothing in there about Tim coming up to your room.
I don't know.
Take a look at that, Mr. Gordon, and answer the question to the best of your ability.
You can also take my word for it that it's not in there.
I won't take your word.
Okay? No problem.
This didn't ask me about. This was asking about other things.
Just please read it to yourself, sir. And let me know if there's anything in there that you said that Tim came up asking for cocaine.
It wasn't.
Showing you D65. This is the statement you gave to us, August 9, 2016. Nothing in there about Tim wanting to come up and get cocaine, correct? Nothing about cocaine in there, correct?
What was your answer?
Nothing in there?
No, the answer is he said no.
Thank you. Your testimony from November 1st, 2016, under oath, during the hearing, nothing in there about Tim coming up and wanting cocaine, correct?
It's 200 pages long,
I don't know.
This is 200 pages long.
Well, you can take my word for it that it's not in there, sir.
I'm not taking your word for it.
Okay.
It's 200 pages long. I'm not gonna do it. I'm not gonna do it.
Is there a stipulation that it's
There's a
not in there?
stipulation, Your Honor, but
It's been stipulated to, sir, that it's not in there. Can I have that? Now I want to talk about this testimony of yours where you said the door, or you heard the door open and shut twice. And that's how you know Tim left and then Tim came back, okay? That's what you said on direct examination, right?
Right.
Okay. Showing you. D 237. This is testimony under oath from December 19, 2016. On page 77, beginning at line 2. Question. Now I want to talk to you a little bit about this, how many times this door opened and closed, okay? Where we left off last time, because you read the transcripts, you said, right? Answer on line 6 says no verbal response. Question, yes. Your answer on line 8, yes. Question. So since you read the transcript, Mr. Gordon, how many times did you tell us during that entire hearing that you heard the door?
Your Honor, just as a form, I mean, if he wants to refresh Mr. Gordon's recollection.
This is an impeachment, Judge. Thank you. Judge, I can cut some of the stuff out, just to, I will do that,
Please.
Judge. '78, Mr. Gordon, line 14. I cut out some stuff here. That you only described hearing the door that night that you talk about once. That's what's in the transcript. Do you take my word for that? Okay. So again, to be clear, you heard that door open and shut one time, okay? Your answer on line 21, okay. Page 78, line 25, question. And at the time that you heard this door open and shut, you were in your bedroom, correct? Your answer on line 25, yes. Question on line 79, on page 79, line 1. You don't see who steps out of that door and who comes back in, correct? Your answer, correct. You just hear the door open and close, correct? Your answer is yes. Question on line 7. And during your testimony on November 1st, 2016, you said that you assumed that it was Tim, correct? And your answer is correct. Mayor, sir? So you said that when Tim came up looking to get cocaine, according to your October 21st, 2021 statement, Tim was wearing his pajamas, correct? Okay. Showing you D240, page 32. Judge, I just need to speak to Ms. Gibbs about this real quick. This is I'm just, do we agree?
Sure.
There's a transcription issue. 32, line 1. Question by Detective Schreck. And what was he wearing at that time? Answer. He had his clothes on. It was his pajama pants and maybe a white t-shirt. Question. Do you remember that or you're not sure? Answer. Yeah, no, I remember. It was pajama-like. It was pajama-like, a pajama. Like he used pajama pants, long pants, and a white t-shirt, or like a beater or something. Yeah, you know? Correct?
Correct.
May I, sir? Thank you. So you say that Tim came back with this $40, and then he came up to your room for the cocaine, right?
Right.
When you claim he did that, he was wearing the same clothes that he was wearing when he came up the first time, correct?
Yes, sir.
Showing you D240, which is your statement, page 41, line 10. You want me to open it to that page? 41. Line 10. So what did he have on? Do you remember? Answer. A white tee. I think he had the exact same thing on he had on before he left, because it was a white tee and sweatpants, and oh man, I think they were pajama pants, black pajama pants, maybe. I mean pajama pants. Question, was it the same clothes that he had on? Answer, I think it was the exact same clothes he had on before he left. May I have the transcript, sir? I read that correctly, right?
Yeah.
Thank you. Let's talk about time, Mr. Gordon. You said you didn't keep track of the time. After you claimed Tim went downstairs until when he returned with money for the cocaine, right? That's what you said, correct? Yes? Okay. So that means, to me, just break it down, you didn't keep track of the time when you claim he left the house, right? Yes?
No, I didn't keep track.
Okay, I'm just confirming, breaking it down a little bit, okay? I'm just confirming these things. That means you didn't keep track of the time of how long he was out of the house, correct?
No.
It's not a trick question. That means you didn't keep track of the time of when he came back to the house, correct? Correct?
Correct.
That means you didn't keep track of time of when he came back upstairs with the $40 to buy the cocaine, correct?
No.
Correct?
Correct.
All right. Showing you D-240 again. Page 36, line 11. Let me know when you're ready there. Ready? Question by Detective Schreck. Do you remember about how much time passed between him leaving your room and then him leaving the house? Your answer, yeah, about 10 minutes, about 5 to 10 minutes. I read that correctly?
Yeah.
Go to page 38, line 11. Ready? Sir, are you ready? You're at 38, line 11?
Mr. Gordon, answer the question.
By Detective Schreck again. Okay, and about what time did somebody come home? Answer. On line 13, it was about 30 minutes later. It wasn't even that long. It was like, question, on line 15. Detective Schreck says, okay, and then your answer, you finish your answer here on line 16. 20 to 30 minutes later, he came back and he had money. Correct? Now let's go to page 44, line 14. Question by Detective Schreck again. So you said he was gone for about how long? 30 minutes? Your answer on line 16, maybe 20, 30 minutes. Question on line 17. And 20, 30 minutes later, how long was he in the house before he knocked on your door? Answer on line 19, maybe 2 or 3 minutes, correct? Ma'am? You claim to have met him outside your room, correct? Yes?
He came up,
Yeah, right outside, or did he come in? Huh?
he came up to the door.
To the door? And then you claim to have given him the cocaine, and you never interacted with him again that night, correct? Okay, if you don't remember, I'll show you, no problem. I want you to be sure. Page 45, line 15. Read from line 15 to line 20, those 5 lines.
So you got to put him outside.
Just to yourself, sir. Let me know when you're done reading them.
Done.
Okay, can you close the statement now, please? Does that refresh your recollection about the fact that after you claim you gave him the cocaine, you didn't interact with him at all that night again, correct?
Correct.
I didn't hear you, sir.
Correct.
Thank you. We talked about the denominations, Mr. Gordon, when we were making our little list here, okay? And you said you didn't remember what you claimed these denominations were, correct?
Correct.
Now, those denominations you talked about in your October 20th, 2021 statement, correct? Showing you a D-240 again, which is the transcript of your statement, page 41. Line 2.
This said it had to be 220.
Line 2, sir,
I just read it.
to line 7. Please read those to yourself and let me know if that refreshes your recollection. It does? Yes?
Yes.
You told Detective Schreck that it was 220s, correct?
I said it had to be 220.
All right, well, let me read it verbatim, sir. Question on line 2. Do you remember if it was 220s or a bunch of 10s? Answer on line 4. Nah, it was probably 220s. Question by Schreck. It's whatever you remember. If you don't remember, it's fine. Answer on line 7. It was 220s. Had to be. Now, this version from October 21st, 2021, you would agree with me that that was the only time and the first time that you said Tim came up to your room that night and gave you $40 for cocaine, correct?
It's not the only time.
Well, I'm talking about what we're talking about here, that night that you're describing. Well, you know what, let me do it this way. I was trying to do it a little shorter way, but let me do it this way. Take a look at D10 again. March 20th, 2014, Mr. Gordon. Nowhere in there do you say anything about Tim giving you $40 for cocaine, correct?
Correct.
Let me talk about now August 9th, statement to us, 2016. Nowhere in there do you say anything about $40 for cocaine, correct?
You can ask me about that.
Nowhere in there do you say anything about $40 for cocaine.
You can ask me about
So the answer is no?
it. No.
November 1st, your testimony under oath, 2016, that's D69. Nowhere in there do you say anything about $40 for cocaine, correct?
Couldn't tell you.
Would the state stip?
I stipulate.
You heard the state stipulate that there's nothing in there about $40, correct? Yes?
Yes.
Before we broke for lunch, you repeatedly said Tim came to you for drugs. He bought his drugs off of you all the time, correct?
We did.
All right. D69, Mr. Gordon. November 1, 2016. Page 68, line 24. Are you there? Actually, hold on a second here. You see that? I gave you the wrong one. You see that? '69, line 24, D69. Starting on line 20, sorry, line 21. Hold on. 68, line 24. I apologize, sir. 68, line 24. Okay. The witness, that's you, Mr. Gordon, right? From November 1st, 2016?
Yes.
It's a situation where you got a guy, like, doesn't go to the streets. he's not in the streets. He's, question, on line 2, who's not in the streets? Tim? Answer. Your answer. Mr. Puskas, on line 4. On line 5, question, he's just one of these hermits? Answer. On line 6, I wouldn't say that. I'm not referring to him as a hermit because he's staying in the house. No, I'm saying that because of getting the drugs. He's not the one that gets the drugs. Question, on line 10, he doesn't cop them? Answer. On line 11, no, Wayne does. Answer. Question, Answer. Your answer. On line 13. So on a daily basis, all those interactions were him talking to Wayne to go get something. Answer.
We're talking about dope here, though. We're not talking about cocaine.
We're talking about drugs, right?
Dope, heroin.
Okay.
We're talking about when you wanna get-
Mr. Gordon, I asked the questions, okay?
Oh, that's
Okay.
fine, but we're talking about heroin here.
Okay.
It's all about Wayne going to get his heroin. I didn't sell heroin, I sold cocaine. So what are you talking about?
Okay. Mr. Gordon, let me read it again. And just answer my question about whether I read it correctly, okay?
Objection has been answered.
The witness is being argumentative, Judge.
I'm not
Just-
being argumentative, you're telling me.
I think you read it already, so just ask
Did
your
I read that
question.
correctly?
Listen, you're talking about Wayne going to get his heroin. Tim didn't get his own heroin. Wayne got his heroin.
That's his response. Your next question?
We're not talking about Wayne. I sold coke.
Page 69, line 21. You know, it wasn't like that every day, but on a daily basis, their interactions were, he didn't have anybody to call. Tim wasn't calling anybody. If Tim got something, it was through Wayne. So on a daily basis, that's just what it was. Correct?
Correct.
So, you just said that we're only talking about dope here, right?
Yes.
You just said that, Tim would get cocaine from you, correct?
Yes.
Nowhere in that statement, Mr. Puskas, Mr. Gordon, did you say anything about Tim buying drugs from you, correct?
No.
Nowhere in that statement did you say, well, he buys cocaine from me and he gets his dope from Wayne, correct? Is that a correct statement, Mr. Gordon?
That's a correct statement.
Thank you, sir. May I have the transcript? May I have the transcript, sir? Thank you. You said you were on probation in February 2014 on direct examination, right? Twice you were asked that question, correct?
Right.
And you said you were on probation in February 2014, right?
Right.
D-228 is already in evidence, Mr. Gordon. That's your judgment of conviction. Let me pull that out. That's the judgment of conviction from 2008, the 2008 case, where you were convicted or you pleaded guilty to distributing heroin. Because I think you just said you don't sell heroin, you sell cocaine, right?
In 2008,
In 2008, you pleaded guilty to distributing heroin on or near school property, correct?
that's not 2014, that's not 2016, that's 2008, Mr. Muslim.
In 2008, you were placed on probation, right? correct?
Correct.
And your probation was terminated on let me get you the right page. November 30th, 2012, correct?
Correct.
And that's the order, basically, from the court terminating your probation, correct?
Correct.
So in 2014, in February 2014, Mr. Gordon, you were not on probation, correct? Correct?
Correct.
Mr. Gordon, this homicide made news, correct?
Correct.
There were many news articles about it, correct?
I don't know, Mr. Maserati.
You don't know, you didn't see any of the articles?
Your Honor, objection.
No.
He's already answered.
He answered the question, counsel.
Okay, no, I just want to make sure he said he didn't see any articles, that's all.
And he said no.
Okay, I'm gonna show you D65. Give me a second. Page 4, line 8. Question. And D65 is the August 9th, 2016 statement, correct? Right?
Right.
Question. That's fine. I don't want you to guess. If you don't know, you don't know. Your answer. That shit's in the newspaper. If I wanted the date to the shit, go to the newspaper and find out. This is 2014. We're in 2016 right now. I do drugs, I smoke weed, and I don't have a good memory at all. Correct? Did I read that correctly, sir?
Correct.
Thank you. Transcript, please. So, not only was it in the newspaper, there was a lot of police presence in the neighborhood, correct?
Correct.
Distributing flyers requesting information, correct?
Correct.
There was a Crime Stopper reward, correct?
Correct.
You were aware of that, right? Yes?
Yes.
Police were knocking on doors in the neighborhood, correct?
Yep.
At one point, I think sometime a few days after, they knocked on 64 Plum Street, correct?
3 days after.
3 days after, looking to speak to Mr. Puskas, the homeowner, correct?
Yeah.
You were in the house, right?
Yeah, but I wasn't taking out the house.
You were-
Everybody else
You were in your room, correct? Other people were also in the house, right?
was.
They were asked to come outside, right?
Yeah.
Okay? You stayed in your room, right?
Yeah.
You didn't come downstairs and say anything to the police about what you claim happened when it happened, correct? Yes or no, sir?
They didn't know I was going to do
But you didn't come down voluntarily and speak to them, correct?
it. No.
Okay, no problem. They left. You didn't contact them at a later date, correct?
No.
You didn't call them, correct?
No.
You didn't go down to the police station, correct?
No.
You did not provide any information in this case until the day that you were arrested on March 20th, 2014, correct?
Correct.
No further questions, Judge. Thank you.
All right, thank you, Mr. Gordon. Mr. Darren?
Your Honor, we have another one, so maybe we take a 15-minute break and then proceed to the
So
dismissal.
we'll take our 15-minute recess at this time. Please don't talk about the case. We'll see you back in 15. Who's your next witness?
Ashley Edwards, Your Honor.
You have an application related to that.
Sure, Judge. I submitted I mean, this is the best we could do on short notice, Judge. I try, I would have done it sooner had or more fulsome analysis had I known, I just found out about it this morning. First and foremost, Judge, and I didn't put that in this application, this issue was not just fully litigated, but beat to death in the first trial, as far as advising the jury of Mr. Stecker's death. That's so, and then, an instruction was given only because the 4C was played. Otherwise, it would be a typical person not mentioned during a trial and not called to the witness stand. You don't give instructions to juries. There's a bunch of people here that are not gonna be called to the witness stand. We're not gonna highlight to the jury that we didn't call them as witnesses, Judge. The jury cannot know that Mr. Stecker's, that issue has been well settled as part of the first trial. But even if you want to reopen that, Judge, and consider letting that in, I mean, we're back exactly where we were after that first trial before the conviction was reversed. We are telling the jury that there's potentially somebody out there who is unavailable, like dead unavailable, right? That potentially may have information, right? Because he was there, witnesses have testified he was there, and then because he's dead, the jury's going to speculate as to what he potentially knew. I mean, that's exactly what we can't have happen. The case law is extremely clear on this issue, Judge. What would end up happening is they'll just basically, there's an inescapable conclusion that man had information, and that information, pointed to some, whether it's drug use or anything else, Judge, that he would have had more information about the guilt of Mr. Puskas. And that being left out there, only what it does, even if you tell them, don't speculate, they're going to speculate. There's an inescapable inference that would be drawn from that. And not only that, Judge, now drugs are in the case. And drugs are in the case in a very different light than you were led initially to believe. Because what were you told initially about drugs being in the case and drugs being the motive, Judge? You were told that Puskas came upstairs for cocaine, and Gordon wouldn't give him cocaine because he didn't have any money or anything to exchange for cocaine. And Puskas said to Gordon, I'm going to go out and find something of value. That didn't come into this case. So now all this stuff about drugs is in the case, and what you have is what? Puskas coming upstairs, wanting cocaine, Gordon wanting money because he didn't want to front him cocaine because he wanted to re-up. Puskas comes back later with $40, wearing the same clothes. So, had you known that presumably during your analysis, Judge, that's how it would come in, you probably wouldn't have let that in. Because at that point, clearly, the prejudice would outweigh any probative value. And to now add on top of that, the fact that there may have been someone else that could have had information about this in the house, but they're dead. The way this is analyzed, Judge, and it's very telling from the appellate division opinion, this is clearly Bankston and Branch. It's clearly information that the jury's going to be wondering about what else did this person know that we don't know about. And it would lead to the inescapable conclusion or inescapable inference that that person had superior knowledge, and because they're dead, the state doesn't have that ability to elicit that. The irony of all of this is, Stecker has my client back in the house by midnight. Stecker has my client leaving the house with nothing in his hands. Stecker has my client coming back to the house, doesn't say anything about blood on the clothes. Same issue that came up before. I can't elicit that stuff. Quite frankly, if Stecker was alive, I think I'd be better off, because then I could elicit these things, which he gives him an alibi. So what the state wants to do now is the exact same thing that happened during the first trial, Judge. I don't know what relevance it has for us to tell the jury that the man died. I mean,
Is that why you're calling this witness?
No, Your Honor, no, I just want to set the record straight first. Obviously, you know, Stecker in the first trial said that he saw the defendant come back with some kind of blood or something on.
He did not say that.
He was asked to wash his clothes. When he came in the door, he stripped and asked to wash his clothes immediately. So we know exactly what we're referring to when we talk about Stecker and what the first trial was about. So for counsel to misrepresent that, I just want to make sure the record is clear. Stecker clearly had information. However, Your Honor, as the state stated, all of the statements that Stecker made are out because he is no longer alive. But that's irrelevant. And I have to say that counsel knows that's irrelevant. The only relevance of us bringing up Wayne Stecker is that through not only Hassani Gordon, but through Rob, Wayne Stecker has been mentioned over and over and over again. And the only thing the state plans on eliciting through this witness in regards to Wayne Stecker, because again, this witness's connection to the home, 64 Plum, was through Wayne Stecker as well. So that's going to come up as well. However, this witness has personal knowledge of going to the house, what happened, and she was there earlier that day. And she'll testify as to exactly what happened when she went there later on that day. And that is all relevant, again, to what counsel has brought up as far as what was going on in that house, who was there.
She was there when he died?
She was not there when Wayne died. Wayne died at some point later on.
So I'm trying to follow you. So you're calling the witness to talk about what she saw and heard that day?
Absolutely.
On the 14th?
On the 14th, why she did not go back into the home later on that evening, going into the 14th and 15th. But she was the individual who opened the door for the police when the police came to the home a couple of days later. She was there and had the interaction with the police, so she was justified for that. And then finally, Your Honor, counsel has brought up, I believe, through, obviously through Rob, but some statement in regards to Puskas and being flush with cash, having plenty of cash, no reason to have to go out there and basically commit this offense. She is able to also testify at the time in question. Not only was the defendant not flush with cash on the 15th, but actually he was filing claims with TD Bank because of fraud happening to his particular account in regards to a specific check fraud that Mr. Stecker and she were a part of. So again, it's the complete opposite of being flush with cash. They were taking the cash from him. The rent checks from the homes, they were taking this cash from him. So it's highly relevant to show that he did not have these funds that counsel claims that he had through Mr. Stecker.
So Judge, I try to follow what the state's saying. You asked the state the question, are you eliciting through this witness that Stecker is dead? And counsel said no. So can we, so
No,
is that?
I'm sorry, I did not.
I mean, that's the first question the court asked.
Let me be
That
clear.
is what I'm asking.
And so
first and foremost.
dead in the sense of why he is no longer, why he will not show up.
But
That
she
is
wasn't there when he died, right?
She was not with him when he died, no.
Okay. So she has this information because somebody told her, presumably, she read it somewhere,
Yeah, Your Honor, but I could say that subsequently she gave her own personal knowledge that he is no longer with us.
But even if she was with him when he died, what does that have to do with us here?
Well, I think that's my point. The only reason.
The reason I'm asking is, it seems to me that if that were a fact that you thought was relevant, I don't know that it necessarily comes from this witness.
Your Honor, but even if I were to bring a detective in or someone, it would still be hearsay in that regard, because obviously that detective wasn't there either. The only reason that it would be mentioned that Wayne Stecker is only mentioned is that he's dead just because of the fact that he will not be here to testify.
There's a death certificate out there somewhere, right?
We have it.
We do have, yeah, I mean,
Which
we do
is-
have it, so it's like, it's public record that he's dead.
So why does anybody have to say that if there's,
Judge, even
I could
if,
bring in someone.
Judge, again, the question is, why would the jury need to know that a witness is dead? I mean, I submitted a letter brief to you.
I read it, trust me when I tell you I read it. What I'm asking now of the state is, well, I don't wanna make your arguments for you, because I don't wanna make any assumptions about why I think you might be eliciting that information. Why is it that you're eliciting
Your Honor,
this
because the state
information?
has a burden here, and our burden is to prove that the defendant not only, what's been the big question here is whether the defendant went out that night. So obviously, if we hear that Wayne is at the house, we've already asked Rob, did you recall? Wayne is another person who's at the house, and the reality is Wayne can't come in here and provide that information. That's the state's burden to bring that person here. If that person doesn't show up, it is on the state to have not either brought that person or explain why that person is not here. That is the reason why I believe it is important for the jury to have completeness of the individuals who were in the house on that evening. What I'd also say, Judge, is just by stating that the man is passed, what prejudice is that to the defense? The defense counsel mentions all this speculation, but again, that speculation could go either way. It could be favorable, as counsel has already stated to the record, of all the favorable things Wayne could have said. The bottom line is, what we don't want is for them to speculate, to say, oh, the state didn't bring this person in. We would have surely liked to have heard from Mr. Stecker to get his account of what he saw that evening. And they should know, based on the state's burden, we do not have that ability to bring them in. So that's why I think it's very important, so that they don't speculate as to why we did not call him.
That's a roundabout way that proves my point. That he would have had information that they don't have. Judge, if I open the door and infer that Stecker would have had information, for example, or if I argue like the reverse Clowens issue, then they can potentially do that, right? They called Rob Sparacco, they asked him about Wayne, not me. They called Hassani Gordon, they asked him about Wayne, not me. This is, Judge, this is exactly why this case was reversed from the outset. It wasn't just a 4C, it wasn't just a 4C, Judge. There was a lot of discussion about the jury not having this impression that there was information out there that they didn't get. So we tell them not to speculate, right? I'm not arguing, I can't, in my right mind, argue to the jury they should have brought Wayne Stecker here for you. I can't do that, right? That would open the door. Nobody's doing that. I mean, and this was settled during the first trial. I mean, I know I keep, saying that. Like, there's a lot of witnesses that had information are not gonna be called. We don't tell the jury, hey, that person wasn't called because X, they're just not called. I mean, I'm not
So I'm
finished.
trying to follow all of your arguments, right? So could the jury not speculate about what information Wayne Stecker may or may not have or have had, whether whether he was alive or not? Could they not?
Can I suggest this? Can I suggest this?
Well, can you
Remove.
answer my question?
Yes, I am.
Okay.
Forget it. Take Wayne Stecker out of the equation. Take a dead person out of the equation. Take any other witness that may have had information. Any other witness. And put them in the place of a dead person. That's a person that's alive. Right? Just for example, like the state's not calling every person that touched this case. We do. That's what happens all the time.
Yeah, what I'm asking you is, it seems to me that there are certain people that the jury may very well expect to hear from, right?
I disagree with the court because.
So, can you let me finish?
Yes, ma'am.
So, if there is a witness that the jury does not hear from, the concern that you raise about the jury speculating that there is some witness out there that may have some knowledge, and now that witness is not before us, could the jury not engage in that very same thing without knowing whether he is dead or alive?
Judge, they are going to, first of all, you're gonna instruct them not to speculate. They're to judge the case as it comes in before them. You already tell them that. when you tell them that a person is really like not available, like really like he's dead, that's gonna make them really speculate. And that's the problem. I don't, what is the relevance, but what is the relevance of advising the jury that he's dead?
How does that allow them to speculate anymore?
Well, because presumably he's a person that the state would have called.
Right.
And that's the problem. We tell them that he's dead, it's not just about that night. The state now wants to elicit information from this witness about thefts that Stecker was involved in. And this witness is actually on video stealing from my client. She's gonna blame it on Stecker. I can't cross-examine Stecker about that. Again, that has again nothing to do with this case, Judge. Nothing to do with this case. Okay? So they were stealing from him, but he still had money. Okay, they want to elicit the fact that she was stealing from him? Go ahead. I mean, that's...
So why don't we get this witness on the stand and get started? At this juncture, I don't believe that it is appropriate for you to ask about this ask of this witness the status of Wayne Stoker. I'll give you the ability to do a little bit of research, and you tell me why this case is, why this information is important to the case, but I do not, in any respect, think that it needs to come from this particular witness. So are there any other objections?
Yes, there are objections. Counsel indicated that this witness was there earlier in the day. I have no information about what this witness observed earlier in the day. It's not in her statement. Sounds like counsel has information that has not been reduced to a report. And under State versus Tier, I'm making an application that that information be barred because I don't know what this witness would say. Tier requires the state to reduce to a report any different information. If you look at her statement, she says, I was there earlier in the day with my boyfriend Danny, and we left. She says nothing about what was going on in the house during the day before. She says nothing about that. So I have her statement here if you want to take a look at it, Judge. She says nothing about anything about, I don't know what she's going to talk about. Now,
How long is it?
the statement is, for that part, let me pull it. So I don't know if they have new information that hasn't been reduced to a report, Judge. My position right now is they may, but I need
Is
it.
there a report of something that she said different than what she said before?
Your Honor, counsel just recited what she said in her report. She absolutely, in her statement stated she was there earlier that day with Danny. She absolutely made it clear that they were using drugs in the house. I don't understand how counsel could say that she was there using drugs.
Okay, so you're saying that she's not testifying to anything different than what was already indicated in her report?
Exactly.
That's their
So-
representation?
But that's not what I heard before, okay, that's not what I heard before. I heard that she was gonna talk about that particular afternoon, about what was going on in the house. Okay, we know people are doing drugs, I get that. And at this point, I'm gonna object to any more things about drugs. I think at this point, Judge, given how the evidence from Gordon came in, I think we need to start pulling back on the drug because it's becoming cumulative and unduly prejudicial. Because again, the testimony that the state wanted from Gordon did not come in that way. And I think, if I remember correctly, you said something to the state about that they operate at their own peril. I forget the statement you used when we were talking about this in the beginning, if the stuff doesn't come in the way that the state says. It has not. And right now, this motive is not here because we're missing a very important element of that motive. And that man was on the stand for hours. Never once said that. So at this point, Judge, my objection is as to cumulativeness of drug activity. We had Rob Sparaco testify about drugs. We had Hassani Gordon testify about drugs. What more do we need about drugs? So if I may finish, Ms. Gibbs, the statement I have here, Judge, says nothing specific about that afternoon. It says they were there and they left. So
So presumably that's what she's gonna testify to, and if she doesn't, then.
But my position right now is no more drugs. It's becoming cumulative and unduly prejudicial. There's no.
You wanna speak to that argument?
Yeah,
Yes, Your Honor. The state ended their direct examination, I believe, Thursday in the morning. We have been here now for the entire afternoon of Thursday and basically the entire day today, talking about drugs after drugs after drugs, about dope sick. I don't think yes, but that was all on cross-examination. If counsel felt in any way that when the state completed their direct examination, that the reference to drugs was not as the state represented, that would have been the time to make this application. But after hours and hours of cross-examination on drugs and what was happening in the house and what wasn't happening, and at this point, Your Honor, that bell has been rung. We've talked about whether they had money or not. This witness is acutely aware of the financial situation that she unfortunately was assisting in putting the defendant in. And at this point, it becomes relevant. The fact she's going to mention drugs after that cross-examination, I don't believe is any surprise at all to the jury.
Judge, it's not about surprise anymore. You're a gatekeeper at this point. And quite frankly, I have it on good legal authority to move to strike his entire testimony. He didn't even identify my client. Like, come on. He didn't even identify that that's Tim Puskas. He talked about Tim Puskas for hours. Not once did he say, or not once did the state ask him, do you see Tim Puskas in the courtroom? I can move to strike his testimony right now. You know what? I won't right now because it's really good for me. But it's ridiculous at this point to keep talking about drugs when the case did not come in that way. We don't just keep going full speed ahead into prejudicial territory. You would have barred this had this been the position the state took from the beginning. And you have an opportunity now to limit the drug talk in this case. They want to elicit the fact that she was stealing from my client. Go right ahead. Okay? We don't need any more drugs in this case. It's become cumulative, Judge. It's not necessary.
Let me hear the witness testify. If it becomes to the point where you, in fact, believe that that's what's happening, you make your objection and I'll rule on it as I hear it.
As it relates to the police coming to the house, what does the state intend to elicit? The state did not make a motion to admit my client's statement, because that's when they spoke to my client. Now, I'm not suggesting you know, that information is not going to come out, that they spoke to my client at some point, but what this witness says a lot of things about a lot of things, Judge, when the police showed up. And again, the police show up there because somebody told the police that, oh, Tim is acting weird. Actually, it was his nephew. Tim is acting weird. You know, I know you guys had a homicide in the area. He's acting weird. Maybe you should talk to him. That's how they show up at his door, by the way. So, and that was objected to during the first trial. The state elicited that information, not that information. They elicited the information that they went to the house upon information and belief. I objected to that, and the appellate division explicitly said that phrase should not have been used because it created the impression that there was other information out there that the jury did not have that led them to Mr. Puskas. That's in the opinion. That was a discussion about that in the opinion. So what is this witness going to say about the police coming? I mean, I asked Mr. Gordon about that. He was very benign. What is she going to say? The police alleged that my client told them he was in Edison.
Presumably it's in the statement that she gave.
Right, Judge, but even though it's in the state, that doesn't mean it comes in because certain evidence is not coming in. The fact that she spoke to Danowitz on March 18th doesn't come in either because she had no personal knowledge about this.
I mean, she's not speaking necessarily about the statement that, well, she's presumably going to testify here today, and to the extent she needs to use her statement in order to somehow refresh her memory about things that did or didn't happen, her statement in its entirety doesn't go before this jury, right?
No, it doesn't. That's why I'm trying to figure out where, like, I don't want a mistrial, Judge. I know the state thinks I want one. I don't want one, right? I only applied for one before because of what happened. You denied it. We're moving forward. I want this case to be done right, Judge, because if my client's convicted because of information that we could have avoided, it's going to get reversed because of the stuff that's, we're very close to the line. And I think because of how thin this case is, any error, Judge, would be harmful error. You know, in cases where there's a lot of proofs, the court says, well, yeah, that was wrong, that was a mistake the court made, that was the thing the prosecutor said, but it's harmless error because there's so much proof. In this particular case, the appellate division was very clear about the fact that any little error in this case is not harmless error because of the thinness of the evidence. And I get the state wants to try to win this case, I get it. But it's not unbound, Judge. And I'm concerned about what this witness is going to say, and that's why I'm asking for some guidance here.
So it seems to me that to the extent you have a statement that she has provided, that you have some expectation of what she is expected to say. If she testifies differently than she did previously, you have the ability to, in her statement that is, or elsewhere, you have the ability to object, right?
I do, but for example, can I give you one quick example?
One quick example.
She claims that my client lied to the police that he was in Edison when they came to the house wanting to talk to him. She claims he did that. That's a ridiculous statement because how does she know that he lied to the police?
Well, I'm assuming that you understand the hearsay rules, right? So to the extent that she's providing information that she doesn't have first-hand knowledge of, you're not eliciting that testimony.
Well, Judge, on that specific point, she does have firsthand knowledge because she answered the door when the police came to the door.
Okay.
And she saw, they pulled them outside. When they got pulled outside, and basically a message went to Tim to say, hey, they have us outside, you gotta come back. He showed up 2 minutes later. So she had firsthand knowledge that when initially someone, that he's supposed to be in Edison, he wasn't because he showed up 2 minutes later. But again, I could get past that. Just, I wanted to answer that question for Your Honor. The reality is that
You're
this
not
was
eliciting
open.
that, is that what I'm hearing? 'Cause
I
just
do not
wanna
need to
move this.
elicit that she felt that Tim was lying, because that was her perception. Tim could have been telling the truth. She's saying in her mind, she felt like it was a lie, because there was no way in 2 minutes he
So
could have gotten back.
her perception of whether he lied or not is not. So let's get the witness in here, let's get the jury in, and you'll object as it comes in.
I'm just trying to avoid comments, that's all. Judge, just briefly while we wait, is she going to say that Wayne was stealing from him? How's that? Like, he's not here.
But they were stealing from him, it's a fact, and she knows it because she was with him. Talk about personal knowledge. She was with him, she took him to the bank, she brought him to the bank, he came back with money. This is a fact.
How does she know
He
he didn't
just
give
said she was on
permission?
video, everything.
She doesn't, like,
How does she know he didn't give him permission?
Bring him in, Judge?
yes. Thank you, be seated. State, call your next witness.
Thank you very much, Your Honor. The state calls Ashley Edwards.
You just raise your right hand for me. Speak up. State your name for the record.
Ashley Lewis,
Spell your last name.
Lewis.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right, thank you. You may take a seat. Just speak up. You're being recorded.
Good afternoon, Ashley. I'm gonna ask you to speak up as loud as you can, because I have to make sure that the jurors back here hear you. So please, there's a microphone in front of you. I ask you to please use that so that you can make sure your voice projects to the back of the room, okay? All right. Now, can I just have, do you recognize the name Ashley Edwards?
I do.
All right, and where is that name from?
That was my married name. I'm now divorced.
All right. And so now you go by Ashley Ashley Lewis?
Yes.
All right, thank you very much. Ms. Lewis, where do you currently reside?
In Raritan, New Jersey.
And what's your current occupation?
I'm a substance abuse counselor.
Can you tell the jury about your profession?
As far as what I do,
Yep.
Judge, objection, relevance.
I'll
Sustained.
I want to bring you back to 2013. Did you ever frequent 64 Plum Street?
I did.
All right. And can you tell the jury about you going to 64 Plum Street?
I was addicted to heroin, and somebody that was living in the home at the time was able to get me heroin, so I was frequenting the home often to be close to the heroin.
All right. And that person's name is,
Wayne Stecker,
and did this happen throughout the entire year of 2013?
I did.
All right. And where would you receive your sources of money to purchase this heroin?
I was stealing from family and other theft I was doing to get my money.
All right. And 64 Plum Street, let me just make sure that we're have the location. I'm going to show you what's been marked as 210. Do you recognize 210? Bless you, Donna.
Yes,
All right. And is that the location you just described?
yes.
All right. So how often were you going over to 210, up to 64 Plum Street?
Just about daily.
All right. And at that time, approximately how many bags were you using?
50 bags of heroin a day.
And can you explain for the jury what your activity would be when you would go there?
When I would go to the house, it was either to get drugs, to wait for drugs, or to scheme about how to get money to get drugs.
All right. Now, when you talk about the scheme about how to get drugs, why would you need to scheme?
Because we didn't have any money. So heroin addicts have to be, addicts in general have to be thrifty.
Objection, Judge. I mean, it's, we're talking about in generalities and addicts in general.
I'm talking about specific
Talk
to
about
her.
her specific.
Correct. And when you say we, who are you referencing?
I'm sorry,
And when you say we, who are you referencing?
addicts.
All right. And 64 Plum specifically?
Me, Wayne, Tim,
And you just referenced with your hand, I mean, we're pointing to the defendant, Mr. Puskas.
yes.
All right, and he has on a, can you describe it?
Blue blazer and a light blue button-down shirt.
Very much. And so, I want to draw your attention to February of 2014. Were you still in the same state?
Yes,
All right. And did there come a time when you say a scheme, did you ever have any scheme that involved taking money from the defendant specifically?
Objection leading, Judge.
Did you and Wayne have any kind of scheme going on during that time?
Wayne and I together did not, no.
All right. And did you get personal knowledge of something that you were being
Objection,
accused
Judge.
of?
Yes,
Okay, what were you being accused of?
Hold on. The objection is as to personal.
That's the knowledge, Judge.
That objection is sustained.
Yep. And to your knowledge, were you accused of something?
yes.
All right, and what were you accused of?
Stealing money from Tim's bank account.
All right. And can you explain to the jury the facts around that?
Wayne was intercepting rent checks that were coming to Tim's house, and he would have me drive and go cash them.
All right. And did there come a point to your knowledge that that became known?
Yes, yes.
All right. And so I want to draw your attention to February 14th of 2014. At that point, do you recall if you tried to go to the home that day?
On the 14th, I did not.
All right. And was there a time between the 14th and 15th that you did try to go to the home?
I did, yes.
All right. And what happened when you tried to go to the home?
I wasn't allowed in the home.
All right. And at that point, what did you do?
I couldn't tell you what I did at that point.
All right. Did you leave?
Oh, yeah.
All right. However, did you come? Was there ever a time that you went back to the house after that?
The next day, yes.
All right. And now, when you went back, were you ever allowed to go back in the home?
Yes, I was allowed to be back in the home.
All right. And when you went inside, who would you interact with?
Wayne, other people that would frequent the house.
All right. Were you aware of another individual by the name of Haas living in the house?
Yes.
All right. Where did Haas stay in the home?
In the attic, the upstairs room.
All right. And would you ever go up to see Haas?
At that point, no, I was not. I didn't have any relationship with Haas at that point.
All right. And at that point, who were you interacting with then?
Wayne, Danica.
Okay. Now, did there come a point where you were at the house and the police arrived?
Yes,
All right, can you please explain that to the jury?
yeah. I was at the house, there was a few of us there. Wayne and Danica had left to go get us heroin, Tim was not at the home, and the cops came to the door. I answered the door, and they asked to be let.
Objection as to what they said, Judge.
All right, just, that's fine. Based on what, after they came to the door, without telling the jury what they said, what did you do?
I refused to let them in to the home.
Okay, and what happened next?
A little while later, they came knocking again at the door, and had everybody that was in the home stand outside the home until they could get a hold of Tim.
All right, and were you ever allowed to go back into the home?
Not at that point, later on, yes,
Okay, eventually you were able to get back in the home.
yes.
Now, okay. Now, at that point, once you went back into the home, were you able to still go frequent the home like you had just described to the jury earlier?
Yes, things were a little different at that point. I wasn't going over like daily at that point. I wasn't allowed in the home
Because of the,
because Wayne told me I wasn't allowed in the home.
Objection to what Mr. Sager said.
yes.
Persisting.
I'm gonna show you what's been marked as 286. Previously provided to counsel in discovery in 287. Your Honor, 286 and 287 I'm approaching the witness with. Take a moment and just, if you recall what those items are.
That's the garage in the back of the house.
All right, and the 287?
That's the inside of the garage in the back of the house.
All right, and are you, you're familiar with that area, correct?
I'm sorry?
You're familiar with that shed, correct?
Yes,
All right, and in that shed, why are you familiar with that shed specifically as it relates to you?
because I've been back there. I've been in it.
All right, and what, can you advise the jury of what you had done in it back in March of 2014?
I had stolen a machine and we opened it up in that shed.
Okay, and what did you get out of the machine?
Money, cash,
All right, and is that one of the examples of the extent that you would go at that time?
yes.
And do you know where the machine came from?
There's objection relevance at this point.
How is it relevant?
Your Honor, I can withdraw, that's fine, I can withdraw. All right, I have no further questions for this witness.
Ms. Edwards, you just talked about a machine that you stole, and you brought it back to the garage. That was you and Wayne?
Yes,
Okay. Mr. Puskas was not involved?
not involved.
Thank you. The police came, that was, do you recall the date?
I believe it was February 16th.
Let me show you a transcript of your statement, see if that would refresh your recollection, okay?
Okay.
I'm going to show you D1 for identification. May I approach, Judge?
Yes.
We're gonna go to page 7. D1, Judge. 7. So I want you to read for yourself lines 13 through 22, okay? Just read that to yourself and let me know when you're ready to answer some questions about that.
Okay.
Does that refresh your recollection?
Yes.
Does the date 1718 around there sound familiar?
Yes.
Okay, and they wanted to speak to Tim?
Yes,
Tim at some point showed up,
he did.
correct?
Yes,
He went with the police,
yes,
and he came back about 10 minutes later, correct?
about, yes.
That's it, thank you.
Any return? None. All right, thank you. You may step down. Do we have other witnesses?
No, I do.
For your next witness?
Your Honor, the state calls Philip Bernard.
Sir, please watch your step, stand in front of the chair. Please raise your right hand, state your name for the record. State your name for the record.
Philip Fanara,
Spell your last name.
F-A-N-A-R-A.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, you may have a seat.
Thank
Please use
you.
the microphone to project to the jury.
Sure.
Good afternoon, Mr. Bernard.
Good afternoon.
All right, I'm going to stand back here, sir, and I'm just going to ask you to try to keep your voice up as loud as possible so that all the jurors can hear you.
I'll use my mother's voice.
Thank you. Sir, where are you currently employed?
I'm an independent contractor for AT&T.
And how long have you been with AT&T?
I've been doing this for AT&T for almost 11 years. Prior to that, there was an additional 16 years where I had various positions with AT&T
All
as an
right.
employee.
Okay. And can you just explain to the jury your job duties and responsibilities in your current position?
I review the records prior to coming into court, and I authenticate them on this.
And did you hold any different positions with AT&T?
Yes, sales, operations, and project management.
Now, I want to draw your attention, I'm going to show you what's been pre-marked as S54B, S54A, and S54.
Just, can we see that sidebar, please?
Remain seated.
Here, may I have this? Mr. Panera, I'm going to ask you to take a moment and look at S544B, S544A, and S544. And I'll ask you questions. And then once you're done reviewing them, we'll have them.
I'm sorry?
And once you're done reviewing them, we'll have the certain dates. It's not gonna be the entire record, it's gonna be certain dates published for the jury. And we can start with S544A. It's gonna be the subscriber.
It says,
544B?
yeah,
All right. And so, do you recognize that?
this looks like a subscriber information from AT&T.
All right, thank you very much. Is that a fair and accurate depiction of what that subscriber sheet will look like?
It appears to be an AT&T subscriber information, yes.
Thank you. At this time, Your Honor, the state would ask for 544B to be published to the jury and see what these evidence.
subject to subject to redaction, Judge, I don't think it needs to be published.
Well, you want to,
I mean,
that's fine, that's fine. I'm gonna, may I approach and I'll
Yeah,
take it
because
back
it
and I'll.
needs to be redacted, right?
That's fine. Your Honor, we can be heard that in a moment when we move along. All right, sir, so, you know what, I'm gonna give it to you because I would like you to give the answers, and I'll ask questions. Can you advise to the jury who was the subscriber on that particular account?
Mary A., I believe it's pronounced Puskas, Puskas, Kas.
All right, and what was the address for that particular account?
113 South Street, Milltown, New Jersey, 08850.
All right, and the telephone number associated with that account?
732-325-8566.
All right, and, let me just see if there's anything else I can. All right, thank you very much, sir. All right, and so what I'd like you to do on S544A, or the S544A is there's columns that are located on S544A. The columns, they have certain titles to them, and that will be for the call records.
I have, I'm sorry,
Take your time.
S544, it looks like a 6 on the bottom after that. The other one just says S5544, rather, S544.
All right, so is there one document there that has call detail records and another one that has the text detail records?
Their mobility usage report, one shows the voice usage and one shows the text usage.
Thank you. And so we're going to go first to the one that shows the call usage. And that should be under S44A. And that A may be a little wonky, but it's gonna be S44A for the record.
If you say so.
Yep, right. And so what we're gonna do now is, again, we're going to have the records subject to redaction that we're gonna go through to have admitted in February 8th through February 23rd of 2014 for those records. And just to be clear, let me put are those records kept in the normal course of business for AT&T?
Yes.
Meaning the phone records, correct. And as well for the text messages, those are kept in the normal course of business as well, correct?
Yes.
All right. And so those records are a fair and accurate depiction of the records that came in for the phone number that you just listed.
Yes.
All right, and can you just give us that main subscriber phone number again?
732-325-8566.
Okay, all right. And so at this time, Your Honor, I look to publish the, start with the phone records under 544A would be from February 8th, 2014 to February 23rd, 2014.
Subject to redactions, Judge, I mean, I don't think they can just wait without
That's fine.
proper
We
redactions.
can redact it at a later.
Absolutely. All right, and so what we're gonna do now is we're gonna have those published, and I'm gonna hand you a pointer. Now, this pointer is able to be used to your right on this particular TV. And when it comes up, you'll highlight this top button. That button makes these go back and forth.
Well, it does.
Go touch that. So this one on top is the one we're gonna go to, right?
Okay.
All right, so, those are the records that you just described that you were viewing, the mobile usage with the cell location, correct?
Yes.
All right. And I want to start, I believe, with entry 243. First, we're gonna go to the top of the document just so that we can, we can stay there. We're on page 16 of this particular document, and we see titles on the top of each column. Can you please explain for the jury what those columns, each one of those columns, the titles on them are?
Okay. Can everybody hear me? Okay. The first is the line item column. That's the line item of a call being placed or received. The next two columns are the connection date and the connection time of a call being placed and received. And in this case, this is still in Eastern Standard Time, this is an old report. The next column is a seizure time. That's the time it takes for somebody to press a button on a device to contact another device. The originating number is the number that's placing the call. The terminating number is the number receiving the call. The elapsed time is the time the two devices are connected to one another. The number dialed is the number that was dialed by the 8566 number. The IMEI is the serial number for that device that's used for that 8566 number. The IMSI is the SIM card serial number that belongs to that particular device. The description is just telling you if it's a mobile, calling another mobile phone directly, or was call forwarding, or it could be a number of different things. And cell location is location of the cell site, the cell site ID, the longitude and latitude of that particular cell site.
All right, thank you very much. And so I would like to move to item number 243 on these particular records, and I believe that that will bring you to the February 8th, 2014, the first entry for that day, correct?
Yes, shows that. Yes.
All right, and so from 243, outlining to the next date that you see for February 9th, 2014, can you indicate the last entry that you see on February 8th, 2014? The number of that item, please, for the jury.
Keep going. Next page. Keep going. Hold. Line item 283, February 8th, 2014. That was the last call being placed or received.
All right, and when you just went through those records and you said, you kept saying, keep going, what were we passing through 244 up until 282? What was that on that particular account?
Various calls or various legs of the call that were either made or received.
All right. And so from 242 to 283, that would be for February 8th of 2014.
Yes.
Okay. All right, so then we're gonna move to 284. Now, from 284, that's for starting February 9th of 2014?
Yes.
All right, and then if we could move down to item number 327, is that the last activity on that particular account for February 9th, 2014?
Yes. Line item 327, the last one call either being placed or received on February 9th, 2014.
All right, and so again, the activity that we passed in between 284 and 327, all of that was for February 9th of 2014?
Yes.
And that was, again, if you could describe to the jury what that was.
Those are phone calls either being placed or received.
All right, then we can move to February 10th, 2014. From 328 item number to, is that the beginning of February 10th of 2014?
328, yes.
All right, and then if we can go down to 358 on these records.
Yes, 358 is the last call being placed or received on February 10th, 2014.
All right, and the activity in between would reflect what calls were incoming and outgoing on the 10th?
That's correct, yes.
Let's move to February 11th, 2014. Entry item 359.
That was on February 11th, 2014.
All right, and is the last item number for February 11th of 2014 number 401? And at this time, we're moving through the record again.
Yes.
All right, and we'll move to February 12th, 2014. We start at item number 402.
Yes, 402 is the first one for February 12th, 2014.
All right, and if we can move through those calls, those to 433, item 433, is that the last date that we have for February 12th of 2014?
Yes, that's the last one.
And then we are going to move to February 13th, 2014. And we'll start at item number 434. Is that the beginning for the 13th?
Yes,
And if we go to 463, item number, would that be all the activity that occurred, incoming, outgoing calls for the 13th?
yes,
We'll move to February 14th, 2014. We'll start with item number 464.
and that's the first call for for February 14th, 2014.
All right, and then we will go to item number 495.
Yes, that's the last one for February 14th.
And that was, and that will,
Yeah.
yep, and that will reflect all the activity in between, incoming and outgoing calls and so forth.
Yes, for that day.
All right, for that day of February 14th. Now we can move to February 15th, 2014. 496 is the entry,
Yes,
and that's the only item number listed for February 15th, correct?
what number was that? I'm sorry.
It's gonna be.
496, yes, that's the
Four-
only one.
For February 15th, 2014.
Yes,
All right, and for that particular item, can you advise whether that was incoming or outgoing?
that was a call that was placed by the 325-8566 number.
So that would make it outgoing?
Yes,
All right, and can you, the duration of that particular call?
it shows 0 seconds.
All right, and at what time?
6:30 in the morning on the 15th of February 2014.
All right, and do you see any other activity on February 15th, 2014?
No other voice calls were placed or received in that day.
All right. We'll move to February 16th of 2014. We'll start with item number 497.
Yes, that's the first one for February 16th, 2014.
All right, and then we'll go to item number 506.
Yes, that's the last one for February 16th, 2014.
All right, so that showed some activity through the 497 to 506.
Yes,
That's for the 16th. Let's move to the February 17th, 2014, please, at 507.
that's the first one for February 17th, 2014.
All right, and then if we go to item 521,
That's the last one for February 17th, 2014.
all right, so were there incoming and outgoing calls on that particular day?
Yes,
Item number 522, what does that represent?
for the first call being placed on February 18th, 2014.
All right, and does that go down with activity to item number 545?
Yes,
All right, and what does item 545 reflect?
the last call being placed or received in February 18th, 2014.
Thank you. And we'll move to February 19th, 2014, starting with item number 546.
Yes, that's the first one for February 19th, 2014.
And the move to item number 568, what is that for?
That's the last call for the number, it's February 19th, 2014.
And there were incoming and outgoing calls on that particular day throughout those 546 to 568, correct?
Yes,
Let's go to February 20th of 2014.
the first call was line 569 for February 20th, 2014.
All right, and if we go down to item number 607, if you could tell the jury what that is.
That is the next page, does that have one in it? 608?
It's-
No, okay. So line item 607 is the last call being placed or received on February 20th, 2014.
oh, And that went through the entire day for February 2014,
Yes,
right? And then February 21st, 2014, if we could start at 6:08.
yes, 608 is the first one for February 21st, 2014.
All right, and item number 626.
And that's the last one for February 21st, 2014.
All right, and that shows the activity throughout the day on that particular date.
Yes,
All right, and February 22nd, 2014.
the first one was line item 627 for February 22nd, 2014.
And if we move to item number 648.
648 is the last line item for February 22nd, 2014.
All right, and then February 23rd, 2014, starting with item number 649.
That's the first one for February 23rd, 2014.
All right, and item number 676.
And that's the last one for February 23rd, 2014.
All right, thank you very much, sir. And now I'm going to ask for you to look at the records marked S554. You mentioned that they were the text record messages for phone number 732-325-8566, correct?
Yes,
All right, and so, again, Your Honor, the state is seeking to admit the sections of a week before, February 8th, 2014, to a week after, February 23rd, 2014, to seek evidence and to publish for the jury.
Subject to redemption.
All right, and so we're gonna have that published again next to you, and we'll go through those things. And on that particular exhibit, it has titles as well as on the top of the columns, correct?
yes.
All right. And we'll go through those with the jury. And while we pull the exhibit up, if we can start to go through those columns, just so that the jury understands the first column, the second column of the particular exhibit.
Yes, the first column is the line item column of a text message being placed or received. The next two columns, the connection date and time of when that text is being placed or received. The next column is the originating number sending the text message, the terminating number that's receiving the text message. Again, the IMEI is the serial number of the device belonging to the 732-325-8566. The the IMSI column is the serial number of the SIM card that belongs to that particular device for that particular number. The description just shows you if it's an incoming or outgoing text message or voicemail announcement. And then the cell location, cell site ID, longitude and latitude, if the information is captured.
Thank you very much. And let me just see if we're ready. If not, then we'll go through it. All right. So we have up on the screen S544, and we're going to move to February 8th of 2014 on those records. And I believe we're going to begin with the item number that you just explained to the jury on the records. We'll start with item number 207. Can you advise the jury what item number 207 is?
It's the first text message either being placed or received for February 8, 2014.
All right. And then I'd like to move to item number 265. What is item 265?
It's the last text message being placed or received with that number on that day of February 8, 2014.
And are those messages in between those two item numbers? Are those messages that are incoming and outgoing textages to the particular phone number?
Yes,
We'll move to item number 266. What is that for the jury?
that's the first text message being sent or received for that particular number on February 9, 2014.
All right, and we'll move down to item number 362. You could advise the jury what that is.
That's the last text message either being placed or received during the day of February 9th, 2014.
All right. Item 363.
First one being a text message being sent and received for February 10th, 2014.
All right, and then to item number 426.
That's the last text message for February 10th, 2014.
All right, and in between there again, if you could explain to the jury.
Those are text messages being sent and received.
All right. Item 427.
The first text message either being sent or received for February 11th, 2014.
All right, and item 482.
The last text message either being sent or received for February 11th, 2014.
All right, item 483.
The first text message either being sent or received for February 12th, 2014.
And item 505.
The last text message either being sent or received on February 12th, 2014.
Item 506.
The first text message being sent or received on February 13th, 2014.
And item 530.
The last text message either being sent or received for February 13th, 2014.
Item 531.
The first text message being sent or received on February 14th, 2014.
And item 566.
The last text message being sent or received for February 14th, 2014.
All right, now, item 567 and 568, what are those?
Those are text messages, just for the only two text messages for February 15th, 2014.
And do you know if those items are incoming or outgoing?
They're incoming text messages.
Moving to item 569 to 571. Are those for February 16, 2014?
Yes,
All right, and are those incoming or outgoing?
those three are incoming.
Do you see any outgoing messages on February 15th or February 16th?
No,
We will move to item number 572.
those are text message, the first text message for February 17th, 2014.
And to item number 582.
That's the last one for February 17th, 2014.
And there were messages incoming and outgoing in the middle of that for that particular day.
Yes,
All right. Item 583.
the first text message for February 18th, 2014.
To item 619.
The last text message for February 18th, 2014.
All right. Item number 620.
The first text message for February 19th, 2014.
And to item number 659.
The last text message for that day on February 19th, 2014.
All right. And that contained incoming and outgoing text messages as well.
Yes,
Item 660.
the first text message for February 20th, 2014.
And item 714.
The last text message for February 20th, 2014.
Item 715.
The first text message for February 21st, 2014.
To item 748.
Uh, 748, did you say?
Yes.
748 is February, the last text message for February 21st, 2014.
All right. And item 749.
The first text message for February 22nd, 2014.
To item 755.
The last text message for the day of for February 22nd, 2014.
Thank you. And last, item 756.
The first text message for the day of February 23rd, 2014.
To item 853.
the last text message for February 23rd, 2014.
And in between that particular date, there were incoming and outgoing text
That's-
messages.
Yes.
Thank you very much. I have no further questions.
Sir, the state went over, well, let me back up. There's about 7 or 8 weeks worth of records here, correct?
I'm not too sure how many weeks, but there's a good deal.
Look ahead and take a look.
Starts on February 1st.
And it ends on end of March 19th or March 20th or something.
It's almost 2 months, yeah.
And the state went over 2 weeks worth of records with you in those almost 2 months of records, correct?
Yes.
All right. Let's take a look at the phone records. Let's go to February 26th, for example, 3 days after the state ended their presentation.
The voice or text?
Start with voice.
February 26th, you said?
Yeah.
I don't know why the witnesses, though, because we just be heard sideways for one moment.
There is no interest on February 26th.
I'll ask you in a second. I think they
That's
want
fine,
to.
that's,
Okay, I'm sorry, what are they?
No, they want to talk first.
I apologize.
You answered that question that there was no phone activity on the 26th, correct?
That's correct, yes.
Take a look at the text activity for the 26th.
No activity on the 26th.
Now let's go to March 2nd.
Voice or text?
Let's start with voice, yeah, we'll go voice and then we'll go text. So let's go to March 2nd.
No activity.
How about text?
No activity.
Let's go to March 3rd.
No activity.
Let's go to text on March 3rd.
No activity.
And this is no activity whatsoever, correct?
No activity for voice.
Not even an incoming text or an outgoing call, correct?
Nothing.
Let's go to February 1st on text messages.
You have one text message.
The entirety of the day on February 1st, you have one text message, correct?
That's all it shows you, yes.
All right. Now, are these in UTC or Eastern Standard Time?
These records are older than the Eastern Standard Time.
Both text and call?
That's correct.
All right. Now, that's cell usage, correct? Cellular usage, right?
Yes.
Meaning it's gonna bounce off a cell tower, and it's gonna connect with the tower, and that's how you use your cell phone, correct?
Yes.
There's cell data that's attached to these records, correct?
Yes.
And you've testified about that in the past?
Yes.
Cell data allows us to know approximately where the cell phone is, correct?
The cell location column just shows you the cell site ID
Correct.
and the longitude and latitude of that cell site.
So it would, of the cell site.
of the cell site.
So if the phone is connecting to that sector or to that cell site, right,
Yes,
it's gonna tell us the approximate location of the phone within a sector of that cell site, correct?
the report only shows you the cell site ID and the longitude and latitude of that cell site.
Okay. It does not show you where the phone is.
No,
There's other reports or other information that we can get from AT&T that would.
yes,
We just don't have it here.
I don't see these reports here.
Okay, all you have are the phone records, correct?
That's correct.
And typically, AT&T will send out what is requested, correct?
Yes,
If that information is not requested, it's not gonna get sent out, correct?
if it's not requested or we don't have it, yes.
So, and the information I'm talking about is the device location. That's what we're talking about.
Yes, okay.
Okay. So if it's not requested, it's not sent out, correct?
That's correct.
All right. Now, when we're talking about cell records, those records do not show iMessages, for example, correct?
That's correct.
iMessages are an Apple iPhone thing, correct?
Yes, that's Apple's network.
Right, so it would not be if somebody's using iMessages, iPhone to iPhone, it would not be reflected in those records, correct?
That's correct, yes.
If someone is using a Wi-Fi application, like for example, are you familiar with WhatsApp?
Yes.
That wouldn't show on these records, correct?
There's a chance that it might bounce off it, but they show Wi-Fi enabled if it comes up.
Okay, you don't see any Wi-Fi enabled anything in these records, correct?
I'd have to take a look. I haven't looked at.
Take a quick gander.
I don't want to cut you off, Mr. Maserano.
I'm-
Do you have much more?
Not much, Judge, just a couple questions and I'm done. Well, it would show Wi-Fi enabled, you're saying, it would show
Right,
that.
it is, so far I don't see anything.
Okay.
I mean, I'm just going through this as quick as I can.
Right.
Um,
But it would show in there Wi-Fi enabled if that was used.
That's correct.
And it doesn't, those cell records don't show web browsing history, for example, correct?
No, it does not.
And that's all I got. Thank you.
All right, one question. You were asked about February 1st of 2014 in those records, the activity. I believe you were asked about either the text. Can you tell the jury the call activity for February 1st of 2014 based on those records?
There's 13 voice transactions.
Thank you. And just for the record, can you, the item number where it begins for February 1st for the call off?
Yes, line item number 1 through line item 13.
Thank you. Thank you very much. No further questions.
Thank you.
Thank you.
All right, members of the, I'll let you get back.
Thank you.
Thank you.
Have a good one.
That is all the testimony we have for you today. Get home safely. Please don't talk about this case. Don't do any research to look for articles or anything else related to this case. We'll see you back tomorrow morning